May I please, Your Lordship? Lordship, with the concern of the other side, I'd like to mention item number 6, Your Lordship.
6.
Lordship, in this case, we have filed the additional affidavit today, Your Lordship, and we have also received the affidavit in opposition, Lordship. So kindly some time may be granted to go through the same, and if necessary, Lordship, we will file the reply, Your Lordship.
Okay. Both sides are represented. Affidavit in opposition is filed on
Lordship, the date I have, I'm very sorry, Lordship, the date I have forgot, Your Lordship. An additional affidavit which is filed today, Your Lordship.
okay. Additional affidavit by respondent.
By us, by petitioner, Your Lordship, by appellant, Your Lordship.
Okay. Both sides are represented on the prayer made by London Council for the petitioner list after 2 weeks on a date to be fixed by the office.
Lordship, may kindly be taken up the matter on 4th of November, Lordship.
I am not fixing a date.
Please, Lordship. Lordship, I beg to mention item number 20, contempt petition. Lordship, there are another 3 connected brief petitions which are pending before this honorable court. So I may have read it, Lordship, that item number 20 may be listed on 20 along with the 3 connected brief petition, Lordship.
We have already filed our affidavit, my lord, in a contempt petition.
Okay. Both sides are represented on the prayer made by Mr. K. Logan, counsel for the petitioner, list on 29/2024, along with give the list.
Yes,
Okay, sir.
read petition 254.
You write and give it to him.
Yes.
Okay.
Deeply obliged.
My lord, with consent from the other party, opposite party, item number 33 and 34. This may be fixed on 26th though. The council is from Mumbai. 33 and 34. This may be fixed for 26th of this. 26th.
33, 34, no, not 26, it goes to 25th. 25, list on the prayer. Item 33, 34.
Yes.
Okay. Both sides are represented. As prayed for by Land Council for the petition. List on 26, that's 25, 9/2024.
Obliged. My lordship. Lordship, with the consent from other side, I beg to mention item number 31, lordship.
30,
31, 31, lordship. Matter may be list after puja vacation, lordship.
after
Puja vacation.
both sides are represented. The prayer made by Land Council for the petition. List after ensuing Durga Puja vacation.
Obliged.
May I please? Your Lordship, with the consent of the opposite party, I pray for adjournment of item number 32. Since Mr. Lemibam is the conducting counsel, he is out of station on personal difficulties. So I pray this matter may be listed after 2 weeks.
List after 2 weeks, both sides are represented. List after 2 weeks as prayed for by Land Council for the petitioner.
Highly obliged.
Lordship, I would like to mention item number 19. Item number 19, Lordship.
18,
We have received the affidavit in opposition. So we may be given some more time to reply.
time to
The time to reply to the affidavit in opposition by the state respondent.
okay. You have taken consent of the other side?
Yes, Lordship.
Okay. Both sides are represented. Just after 2 weeks, so as to enable the petitioner to file affidavit in reply in the matter.
2 weeks, Lordship.
Hmm?
After 2 weeks.
May I please, Your Lordship? Your Lordship, I would like to mention item number 9 to 15 and 17.
Why?
9 to 15 and
Why?
17.
Why?
Your Lordship?
Why do you want an adjournment?
Yes, sir.
Why?
Yes, yes. Your Lordship, the Senate Council is out of station. Therefore, matter will be adjourned after vacation, Your Lordship.
Okay.
Your Lordship, I'm here from the petitioner side. They have taken 5 adjournment for filing affidavit in opposition. Four adjournment.
Let the matter be called, then we'll see. You need to pray when the matter is reached.
Your Lordship.
Lordship.
May I please, my lord, I beg to mention item number 3 and 4, my lord. My lord, I'm appearing on behalf of S. Pandey, my lord. He's not well, my lord. If the matter may be taken out on 25th, my lord, of this month, my lord.
Just give me item 3. Item 3. Now, both sides are represented on the prayer made by learned counsel for the petitioner based after ensuing puja vacation.
25th, my lord.
Huh?
On 25th, my lord, September, my lord.
25th.
Yes, my lord.
Okay. 25/9/2024. Yes.
My lord.
Issue notice in this matter.
My lord,
Issue notice in this matter.
notice, my lord, since the basic issue, my lord, is disputed. They says, my lord, the area, the properties comes under my lord, and they are claiming for the compensation. We say there is a cost, my lord, meaning thereby, my lord, they have constructed these properties, my lord, just to get the benefit of that scheme, my lord. And further, my lord, re-verification report, my lord, as per re-verification report, the total amounts count, my lord, 4,52,000. If they are not agree, my lord, they can appeal, my lord. Under Lara Act also, my lord, under this, what you call, Jumland Act, my lord, as per amended, my lord. They can make a representation to the secretary or commissioner, my lord. Or else notice may be issued, my lord, no issue, no problem.
This land was acquired under Zoom land.
Yes, my lord, 1947, my lord, yes, my lord.
This is which volume?
Volume that should be.
Volume 1.
Volume 1 में? Volume 1. Amended is somewhere in 2023 or 24.
Yes, in view of appeal and revision, why should we entertain a writ petition?
My lord, there is a office memorandum in respect to the procedure to be adopted while disposing and determining the reasonable rate. Because the Zoomland Regulation 47 does not provide any procedure. It just says that the government may acquire any
You
Zoomland.
see, if there is a aberration of procedure, then also in appeal or revision, that can be rectified. You see, the additional advocate general says that there is a dispute with regard to the construction because they say that the construction was made just to extract extra compensation. So that is a matter of evidence.
My lord, it is admitted by the respondent authorities that the structures were already in uses prior to the notification was published.
Where is that?
Because the proceeding was conducted to determine the reasonable rate. Page 36. 36.
Yes.
This was the proceeding conducted by the Deputy Commissioner
Yes.
to determine the reasonable compensation rate.
Yes.
May I lead to page 37 on the second last para?
Page?
Page 37, second last para.
Yes.
Further PAFs, that is the project affected families, were not agreeing to the excluding of compensatory orient structured assets from the assessment as the same was created before issue of land notification. After exhaustive meeting and discussion on 12/4/2023 and 9/5/2023, the majority of the PFs have agreed on payment of 25% of value of structures assets, which was created just before the notification of the acquisition. Considering the urgency and importance of the project, the land requiring body and acquisition authority has agreed to recommend for payment of compensation recently created assets just before notification at the rate of 25% of the structures assets to resolve and address their grievances and demand. The respondent authorities, my lord, they are not disputing that the assets were created after the notification. They have admitted on records that the assets were created before the notification. My lord, what is relevant is that the assessment has to be done on the date of the notifications. Whatever structures existed on the date of the notification, those structure has to be assessed.
This is page 63 is a semi RCC construction. Very
Yes, sir.
good. Page 63 is a semi RCC shed.
Yes, sir.
Yes. Where is the RCC? I don't find it. Maybe perhaps some of your friends can assist you to find it out where the RCC is in
Sem-
page 63.
Semi-RCC, Your Honor.
I understand. Semi RCC means there must be some 1 inch of RCC. Can somebody find it? With land the additional advocate general. You can find it.
I'm sorry, Mala, it's a bamboo and by this some
You see,
tina set is there, Mala. There is no any concrete.
this is
evidence.
semi RCC. It's a disputed question of fact. Even I can't find it. But perhaps I can't. I am a bispectacle man. I don't have a perfect vision. I don't have a
It
perfect
is there
vision.
in their assessment report, Your Honor. They have assessed it. Initially, they made first.
No, this is the assessment. We'll have to send it to the appellate authority because I can't find it. If you're wanting assessment of this, it's a disputed question. If you want an assessment of this as an RCC shed, semi RCC shed, it's a disputed question of fact.
They made two assessments. Initially, they made.
I am not of that. You are showing me something which is a semi RCC. I'm trying to find out where is the RCC. If it is not, there is a disputed question of fact. I should not be examining it. I should have seen it. In a writ petition, I would not examine the veracity of a photograph. It is for the appellate authority to do it. On this ground alone, we are sending it to your to appeal.
My lord, the respondent authorities are not disputing the existence of the structures assessed. They are only saying that the structures appear.
This would have no value at all. If this is your construction, it has no value at all. Except for the CIC proof. I think the Kvadiwala will the vendors to take this old tin. They would purchase it at not more than 10 rupees a kg. I don't know the.
My lord, I have annexed the at page 72 the.
No, you see, this is the cost of this RCC, semi RCC shed is 1 crore 43 lakh, 1 crore 43 lakh 13,600. That part of the RCC, I don't find it. This house would be hardly this tin roof or CIC roof will not be more than 20 feet by 20 feet. With my limited vision, I see a bamboo wall. This bamboo wall will not be 20 into 20 into 4. Is 400 into 4, 1,600 square feet.
My lord, at page 72, I have annex the structures. Page 72. Seventy-two.
This is not, at no stretch of imagination, it is 1 crore. Go before the authorities. The size you have given here. What is the size here? Here you are given 336 square meter. I give an estimation of 400. 677 square meter, 336 square meter. 336 square meter would be 1 crore something. That means we are sitting in a room. If this is, we calculated that 600 square feet, this will be a 2 crore rupees room. Full RCC.
My lord, they have a fixed rate to calculate per square meter.
Don't worry about that. At
On-
least the court can't agree.
I'm
The
only
projection you are
challenging
making-
the, I'm only challenging the
No, the
exclusion
projection,
of
you
the
see,
assets.
there must be some reasonableness. This thing you are projecting, for that we will not assure it. It must be convincing. 336 square feet, square meter.
There are other
For
assets
1
also.
crore 43 lakh.
My lord, there are other assets also. I am not on the amount. The amount can be, it can vary because after assessing,
They are offering you 25% of this. It's not even worth 1% of what they are offering. I'm sorry, it shocks the conscience of the court. 336 square meter, we can't ask you to go to authorities. We adjudicate it for 1 crore 84 lakh. No, sorry.
my lord, I am not on the amount.
You see, the things must be shocking to the court. You have suffered such an injustice that it should shock the conscience of the court. Where is the injustice?
They have not included in the calculation.
Go to
In the computation of
authorities,
the-
file an appeal. Your name?
My lord, there is a, given a,
So whatever loss you have suffered, we are not
the
interested.
assessment has to be done on the date of the publication of the notification.
You are not reasonable. 1 crore 84 lakh is shocking to the court. You are not reasonable. Your name?
Christopher.
Pardon me?
Christopher Burman.
Christopher. Well, when it comes to the petitioner. Also had Mr. R.S. Nawam Ranad, Additional Advocate General for the state, assisted by Ms. P. Pangu Ranad, Advocate, Mr. D. Kamrup Ranad, Standing Counsel for the Land Management Department, and Mr. M. Katur Ranad,
6 and 7.
DSGI, appearing for respondent number 6 and 7. So Advocate General, Additional Advocate General would be for respondent number 1 and 4. And Mr. Kandup would be for
2 and 3, ma'am.
2,
And 3.
2, 3, and 4, I think. 2, 3, and 5.
2, 3 and 4. Yes, ma'am. No,
Huh?
my lord. I am for 2 and 3, ma'am.
2 and 3, okay. Then Mr. Nawam will be for 4 and 5.
1, 4, and 5.
1, 4, 5, 6 and 7 by Mr. Kato. the non-inclusion of the entire structures existing on the land which is sought to be acquired, which is proposed, which has been acquired for construction of road from Yingkiong, Yingkiong to Mayong. Was agitated by the petitioner before the authorities. Full stop. It is projected that without proper assessment of the value of the assets which were created prior to the land acquisition notification, some of the affected project affected families have agreed to receive 25% of the cost of assets, to which the petitioner does not agree. Accordingly, by filing of this writ petition under Article 226 of the Constitution of India, the petitioner sought for quashing of the impugned decision by the respondent authorities taken on 9/5/2023 for setting aside the verification report prepared by the inquiry committee, thereby awarding compensation of rupees 4,52,150 for the assets standing over the acquired land of the petitioners. The petitioner has also paid for a fresh assessment of the land and assets at chainage number 1.502 TO2 1.564 of the said border road organization road. And to include the total value of assets standing over the acquired portion of land in light of Office Memorandum dated 2/6/2021. Next, the learned additional advocate general has submitted that if the petitioner is aggrieved by the valuation of the land as computed by the authorities, the Balipara Tirap Sadia Frontier Track Jhum Land Regulation 1947 provides for appeal and revision under Regulation 17. Which enables the administrator who is the administrator?
My lord, as per Jumlat Act, my lord, it is the government, my lord.
Government.
Yes, my lord. as per that new amendment. As per this new amendment 2020, yes, 2024, my lord, is the government, my lord.
It is called the government. Now
Yes,
it is
madam.
not administrator.
No, my, it is there in page number 81, my lord. This is Amendment Act 2024, my lord.
81.
Page number 81, last page.
Yes.
Serial number 3, my lord. Substitution of ward administrator, my lord.
Okay. The appropriate government
Yes.
is empowered to call for and examine the records of any proceedings or trial under the provisions of the said regulation, and has the power to set aside, modify or alter the order or sentence passed by the subordinate authority. First of all, having noted the nature of structure claimed to be standing on the land, which is projected to be a semi-RCC shed, for which value of rupees 1,43,13,600 is claimed. And in view of the dispute raised by the learned additional advocate general as to the valuation of the structure, the court is of the considered opinion that the adjudication of this writ petition would entail an inquiry into the disputed question of fact. Accordingly, the court is disinclined to entertain this writ petition, as disputed questions of fact would be involved in this writ petition. Accordingly, the petitioner is delegated to approach the appellate public revisional authority, is advised in respect of the grievances raised in this writ petition. Next paragraph. As the writ petition has not been heard on merit, it would be open to the petitioner to take such to make any just clarified that this petition has not been heard on merit. The opposite observation, this writ petition stands closed with liberty as indicated above.
Obliged.
My lord, in that case, if this particular is not being considered, I would withdraw with the.
Withdraw it. Mr. Advocate General. Additional Advocate General, Mr. Nawam,
My lord.
he desires to withdraw it.
I'm sorry, my lord.
He is desiring to withdraw it. You modify the order.
My lord.
He is desiring to withdraw the writ petition.
It's up to you, your lordship, my lord. Your lordship has, my lord, spent so much of time dictating, my lord. It's up to your lordship, my lord.
That's okay. We don't want to discourage. You see, he's a young lawyer.
Yes, my lord.
My lord, with liberty
We
to
don't
file
want
afresh.
to, Discourage them. The constitutional
With liberty to-
withdraw this petition with liberty to approach the appellate of the revisional authority prescribed under so and so act. First of prayer is allowed, matters stand dismissed from withdraw with liberty as prayed for.
With liberty to file afresh.
Yes.
May I please, your lordship, this is regarding the petitioner is not being allowed to join his duty
and
He's not
petitioner
been
was
allowed to join the duty. Yes, who is appearing for the respondents?
Union of India.
I am for the respondent number one, my lord. Rest respondents are my lord, society, my lord. Honorary Secretary, Sainik School Society, my lord.
We take it up on Friday. In the meantime, you take instructions. Why is not being allowed? Correct?
My lord, Friday.
By Friday. The petitioner,
Your Lordship, this Friday. This Friday.
your name?
My name is A. Bhattacharjee.
A.
Bhattacharjee.
A. Bhattacharjee.
No, A. Bhattacharjee.
Mr. A. Bhattacharjee, learned counsel for the petitioner, projects that the petitioner has not been permitted to resume his duty as you are serving as
As fourth grade multitasking staff.
okay as grade
That is
4
plumber.
multitasking staff in Scenic School,
Niglok Ruski.
Niglok, Niglok.
Niglok.
Full stop. There are extra copy of the petition be provided to Mr. M. Kato on at CGC so as to enable him to obtain instructions as to why the petitioner has not been able to join the duty. Full stop. List again in the motion column on Friday.
Friday, 20.
Obliged.
Fridays. Give me an extra copy, Mr. Bhattacharjee. Give me an extra copy.
May I plead your lordship? This is contempt petition, my lord. Respondent number 1 to 4 has filed, and respondent number 5 has filed the reply in this contempt petition.
Mr. Kandu is here.
Kamdu was here.
Mr. Kamduk is not here.
No, my lord.
No, Mr. Kamduk.
Kamdu.
So then we'll have to issue a warrant of arrest against the respondent numbers. Against the respondents. Try to find out Mr. Kamduk if he's there after some time. Let it remain. When he comes, we'll take it up. Yeah, Wi-Fi password. Just a minute. Huh? Okay. Okay. Mr. Navam,
My lord,
on the internet, we find that this Shobit University is accredited with A grade and valid for a period of 5 years from 2012-2022 in the second cycle.
my lord,
That means first cycle would be prior to 2022.
22.
This degree was obtained when?
This degree was from, my lord,
In 2014.
2014. That means
It will not be valid.
yes, that was only for 2022.
No, 22 is the second cycle.
Second, yes.
What is the first cycle? We don't know.
My lord.
And this university is not a party here. Because to hold a degree to be invalid, we must hear the university.
Correct, my lord. Correct, my lord. Then second, my lord, from department side, they have given a complaint to the SIC to make a inquiry whether the certificate owned by the private respondent is forged or not. Now,
That
now-
inquiry would not be appropriate. It's not a question of the degrees forged. Degrees there.
I
but
can understand the very validity of the university in question, your lordship. Yes, correct, my lord.
Okay. Now appears on call for the petitioner. Mr. Howard, Mr. R.S. Navam, Leonard, Additional Advocate General. assisted by Ms. P. Pangu, and government advocate is present. Next one, the learned additional advocate general has submitted that the petitioner claims that the degree obtained by distance education by the respondent number 4 is projected to be invalid. Full stop. However, it is submitted that the investigation handed over to the SIT is not yet completed. Full stop. He also submits that without the university being arrayed as a party, comma, he questions as to whether in the absence of the university as a party in the writ petition, the degree conferred by the said university can be held to be invalid. First of all, in view of the nature of query raised, the court deems it appropriate to adjourn the matter as the petitioner is absent on call. First of all, next, on the next date, the learned counsel for the petitioner shall address the court on the maintainability of the writ petition in the absence of the concerned university as a party respondent in the writ petition. Just add there one line more. I'm adding one line more here. Without university being a party and or without UGC being a party. Because if it is not
Under the
accredited by
UGC.
UGC, they will
Ballot.
be saying it.
And,
You've added few words in your mouth.
Ballot, this matter to be listed after ballot.
List after 2 weeks.
2 weeks, ballot. Obliged.
May I please, Madam?
Yes.
Madam, this is a criminal petition, Madam, under section 482, Madam, invoking an inherent jurisdiction of this honorable court. For quashing the FIR,
Where is the FIR?
my lord will find FIR at page number 27 to 31, my lord. Of my
Page
27, it starts from page 27, my lord.
7.
My lord will find, my lord, straightly come to page number 30, the FIR. May I read, my lord?
Just a moment. Under which provisions this FIR has been registered?
My lord, you will find, my lord, 120B, criminal conspiracy, my lord.
No, where is that?
My lord, page number 30 at the top, my lord. Page number 30.
Yes.
My lord. Even charge sheet has been filed. During the pendency of the present petition, my lord.
Okay.
And the charge sheet also, my lord, same section.
The name of the two petitioners are, one is Ms. Tendi Lamo.
My lord, see
What
the
is
late,
what is the second name?
Michung Kamba, my lord. So far, my lord, petition number 2 is there. Against him, my lord, now charge sheet, my lord, in the absence of procedural sanction, my lord, he has been dropped.
Okay, so only one remains.
Now only the one, my lord. Michung Kamba is the second petition.
Yes.
My lord, before coming, my lord, reading this FIR, my lord, some facts is very important, my lord. It's not in dispute, my lord. Basically, my lord, this petitioner, they are from, my lord, this Pema Court area from Tuting, my lord. This is one circle, my lord, at the ADC circle, ADC headquarter area, Tuting area, Upper Siang district. They profess Buddhism, my lord. By religion, they are Buddhist, my lord. So, in the Upper Siang district, my lord, they are minority, my lord. Because other communities are also there, my lord. This respondent party, they are the majority community, my lord. The Simung community, my lord, which comes under Adi community. This Memba and Khamba community, my lord. So they own a community land. This is measuring about 1154 acres of land. This is their community land. So since their forefather, ancestral time, they have been in continuous
That land is the petitioner or the respondent?
land, my lord.
That land you are saying
My lord, now I'm saying that we are saying this is our community land.
is your community.
Community land. Now, how the dispute is started, my lord, I will apprise my lord. It's a community land, it's a mountainous area, my lord. So, since our ancestor, we have been in physical occupation and we have been using that mountain. So, within that community land, my lord, there is a particular one place.
Now, who has recognized this as a community land?
Yes.
Any authority have recognized this as a community land?
No, my lord. As on today, neither they have any document, neither I have any document. This is the thing, my lord, because in the state of Arunachal Pradesh, my lord, the definition of the Arunachal Pradesh land record is something like that. If the land is not belong to the government, then automatically the others are the owners, my lord, either the community or the individual. So it is something like that, recognized, my lord.
No. You see, I always have very very odd feeling, very, what do you call, amazing thoughts come to my mind. You see, I'm also a community. May not be from this state, but I have a community. Now, assuming in my area, the land belongs to a community. So can I just wish that this is my community land? There must be some authority to recognize it.
Well, under Act of Arunachal Pradesh, it is recognized. Under Arunachal Pradesh Land Record and Settlement Act 2000, my lord, it is recognized.
It is recognized.
Recognized. That's
So
why
therefore, there must be an entry in the
yes,
government
it is
records
recognized, man. Statutorily, it is recognized. So
as your land.
yes, yes, man.
So which authority has recognized this?
The Act itself, my lord, Arunachal
No.
Pradesh Act,
Act, there must be some performing authority.
my lord.
Under this act, who is the authority who is empowered to record the land as a community land?
Yes, my lord, my lord. Then generally, my lord, LPC has to be issued.
LPC.
But,
In this case, there is no
with
LPC.
neither of the party we have, my lord, LPC,
Okay.
my lord. So ancestral land within this area, my lord, It is a completely, my lord, mountainous area, my lord, snow-capped area, not the entire area, but within this, the disputed side, not the entire area is not in dispute. Within this community land, what our case is, there is a particular place called Rio Tala, my lord. Now, we treat this area place as a very sacred place, as a pilgrimage site, my lord. Not only from the person professing from Arunachal, all over the world, my lord, people visit, my lord. Annually, people visit for pilgrimage purpose. We consider this place as a abode of Avalokitaskar, its name like that, my lord, which is regarded as the Buddha of compassion. So this is something, my lord, very, from the religious context, it is very sacred for us. Not only for our community over there, rather it's for the entire humanity, my lord. This has that importance, my lord. There are so many evidence also, my lord. Books are written there, my lord. Foreigners also visit, my lord, there. So this is, my lord, but since it is in our place, so we have one association called Pema Court Welfare Society. So petition number 2 is the president of that association. So we have taken initiative, my lord, because this is not something, this is not motorable road. You have to go by foot track 3-4 days, and you can have access to that area only during the month of August to October or something like that. Because before that, you cannot have access. Winter, impossible, man. So when people go for pilgrimage, my lord, after foot trekking for 2, 3, 4 days, my lord, there if you go there, how people will stay there. So that's why, considering all those aspects, my lord, we as a community member from our own pocket, we have constructed even foot track road from our own pocket. And in the year 2019, my lord, a monastery was built up. 2019. We built a monastery 2019 in the Riotala area, and we placed a statue of this Avalokitaskar. It's a statue had to be carried by people. It's a 5 feet something huge statue, my lord. We did very hardship, and somehow we managed to keep there. And there we build a monastery, my lord. Is a, of course, with wooden log, my lord, because, and kitchen along with, so that the people who comes for the pilgrimage, my lord, they can have rest, they can sleep there, they can cook their food, all those things for that person in 2019. Till that time, then, my lord, till 2021, there was no any whisper from anybody. We have been, since our ancestor time, we have been using this area for pilgrimage site. 2019 constructed, we have been doing no issue, nothing. All of a sudden, my lord will find on 5/9/2020, Gangbura of one village called Simong village, all of a sudden serve one notice to the petitioner number 2 on 5/9/2021, my lord, kindly I will take to the annexure. My lord, first I will take the facts, later on I will take to the annexure, my lord. Briefly, I will tell the fact. Then, my lord, now for the first time, this Simong community, they are saying, no, where you have constructed this monastery and the place which you are claiming, this is our community land. Now, my lord, they have made counterclaim in 2000 saying that this is our community land. We used to do hunting over there. So since our ancient time, we used to do hunting over there, or we used to do some rituals. Now, counterclaim in 2021. Now we replied that notice, and my lord will see in the notice, my lord, we were threatened, saying, you immediately vacate your monastery, or else we will destroy it. That is there in the record, my lord, in the legal notice. We replied, said, no, this is our land. Since our ancestor, we have been doing. This is very important for us. This is our reply. Matter reached to the deputy commissioner. Very interesting, my lord. Deputy commissioner, without having authority, without going through any evidence, on 4/10/2000, declared ownership in favor of the opposite party. Then this 4/10/2021 was put to challenge in a writ petition, my lord. And this honorable court was pleased to set aside and quash, my lord. Then, my lord, will find very interesting.
That is this judgment of 9/6/2022.
My lord. My lord. There was causes, sir. My lord, then what happened, my lord? In the meantime, between either 16 or 24/10/2021, my lord, this opposite party, they completely desecrated the entire monastery, burned the monastery, my lord, idol, destroyed, dismantled, put on fire, my lord.
What, which date?
16 and 24, between 16 and 24/10/2021, my lord. During the when I challenged the matter, when the matter was pending before the Honorable High Court, my lord, the opposite
Which
party
date? Which date? Give the dates.
between 16 or 24/10/2021.
Yes.
Opposite party gave effect to their earlier trade. They said, we will vacate if you don't do. What they did, they put on fire. It is nobody stay there, it's very far area. Put on fire, entire idol was burned, entire SS, all religious relics were there, things were there, my lord. Vandalized everything, my lord. This sacred religious article, all those things. Then we lodged a FIR on 28/10/2021. Then we lodge a FIR. Very unfortunate, my lord. Police says that we could not, incident happened. There is no dispute. Police said that we could not find out the culprit. We approached this honorable court first. In the meantime, charge sheet was filed because they were not even undertaking proper fair investigation. That's why we had to approach this honorable court. But in the meantime, when the matter was pending here, they filed the charge sheet. Not charge sheet, my lord, final report. Then again, we pursued a protest petition file, my lord. Then, my lord, learned JFC was pleased to order for further investigation, my lord. But again, my lord, second time also, my lord, same final report saying miscreants could not be traced out. Thereafter, my lord, the matter is now pending before this honorable court. So far, we want the transfer of the investigation from that particular concerned police, because 2 times they are saying that we are unable to find out the miscreants, my lord. This is the stage as so far that for burning the, my lord, our monastery, my lord. That is the stage. After that, my lord, the issue become bit tense because community involved. Then matter reached to till CM level. The meeting was held. Then the Honorable Chief Minister came with a proposal that both the party, we should be also allowed to use the pilgrimage site, and other side also should be allowed to use for sort of amicable solution. But in the meantime, the complainant of this particular case, my lord, they are the President and General Secretary of the Youth Welfare Society of Simon Community. They write to the Secretary, no, we are not going to accept any resolution proposal of the CM. We are completely against. We are not going to give our land. And in the same vein also, my lord, petitioner number 1, the lady, is also she was also the president of Pema Youth Association. She also right, we are also not agree because this is our ancestral land, we have been doing it. So in that way, matter remain pending. Then, my lord, what happened? Then, my lord knows, as of my case is what, my lord, that since they have burned, they have desecrated everything, then ensuing pilgrimage time was coming on. Then, my lord, since the land is under our physical possession since many times, then on 24/7/2022, petitioner, my lord will kindly note, the petitioner number 1 being accompanied by some youths of our association, we went to the Ryotala area. We constructed a temporary wooden monastery in place of earlier monastery. Because, my lord, the pilgrimage season was coming up, my lord. Because from onwards, August, my lord, some people will go for the pilgrimage, my lord. So that where they will stay. For that purpose only, we went there and constructed a wooden temporary hut, something, my lord, so that people can sleep at least, my lord. It's so windy area also. It's a complete mountainous area. I am told, my lord, very beautiful place, my lord. Then, my lord, at that point of time, we were accompanied by even one BJP, this Ananta Narayan Misra, who is the state general secretary of BJP. He also wanted to have visit of that religious place. He accompanied with us. We went there, and in his presence only we constructed that one. It is nothing something we want to commit any crime or something, my lord. Now the issue is that because now the FIR is something that we constructed this temporary wooden monastery, my lord. Therefore, they lost the FIR. Say, why you construct? Then I will, my lord, reason why immediately FIR was registered, how we were arrested, my lord, I will come to that situation. Now, when we constructed that temporary structure, then from the opposite side, there was a pressure to the district administration saying we all, because my lord, there is a majority, my lord. So we will go, we will destroy by ourselves, or unless you do something. 144 order had to be imposed. Then they said one condition. Okay, we will not go and destroy, but you have to immediately arrest them. And my lord, very unfortunate, I am telling my lord, petitioner number 2, the very old teacher, he was something more than almost 60 years age. He did not even go there at the time. He was immediately arrested. During the resolution meeting, some of our members were forced to accept the resolution, but this petitioner, he refused to accept resolution at the initiative of the deputy commissioner. He was taken from the meeting itself and put to behind the jail. And my lord has seen what is there in the FIR only because in place of all monastery, we constructed. We are not denying. We're saying that we constructed because we have been using, land is in our physical possession. This is very sacred. You people have desecrated, you have put on fire. How it's for very important. Where will we stay? It's a, my lord, only hurt. I will show the photographs, my lord. Then, my lord, in this manner, my lord, then my lord will find very interesting. Then what the opposite party does is like, they immediately take up the matter to their own village level.
Because Mr. Sunar, in a 482 application, you just to consider whether there's a probity in the allegation in the FIR or not.
Yes.
The other part of the entire edifice is not very important.
Not, but my lord will be aware, my lord, under what circumstances. Because my lord, under what circumstances this FIR happened to be registered only for that purpose. Now I'll come to definitely the FIR, my lord. Because background is like, this led to the filing of FIR. Now, my lord, after that, they held a kebang within their own village without intimating us. They passed a ex parte kebang decision in their favor. We have put into challenge into a civil appeal, my lord. Then matter is pending. Now, what I am referring this matter, so far land dispute is concerned, this is pending before the competent civil court, my lord. I think there is a matter of record, my lord. Now, my lord, I'll just start. Now I'll come to the annexes, my lord. My lord, FIR, my lord, page number 30. My lord, my understanding reading this FIR into 30, my lord. Where is the, my lord?
I'm sorry, sir. Sorry. I'm sorry, my lord, for the interruption. If my learned friend is going into the question of the ex parte Gabang decision, then I'll have to take instructions because there was a letter from their side saying that we will not be able to attend today. Before that Gabang was held. If he's going into that.
No. I was not aware that I was hearing a Gabang appeal.
That's since he is referred to it.
Statement, he made so many statements.
Yes,
People make so many statements.
Yes.
But everything you don't.
Otherwise, yes, Lordship.
Why I referred, my only purpose, land dispute is pending. Not more than that. Not about the merit of the claim, my lord. My lord, let's see, my lord, page number 30. What is the FIR? Now, the main issue. This is the background, my lord. Now, my lord, my understanding, reading, if I repeatedly keep on reading, my lord, even, my lord, where is the ingredients of 120, 153 to 95A, my lord? Now, if suppose, my lord, if I am having a possession of a land, my lord, if I construct my lord, their my lord, building, my lord, or something like that. Somebody has demolished it. My lord. Now, my lord, can you say, and that too, my lord, not to hurt any religious sentiment. There already my monastery was existing. Had it been something, my lord, okay, for the first time, rather, my lord, these sections are appropriate, applicable to the informant party, my lord. They have hurt our sentiment. They have outrages our sentiment. They have created hatred amongst the community, my lord. How my construction, my lord, that to a very small hurt to rest during the pilgrimage time, my lord. My lord, thereafter, my lord, page number 32, my lord, kindly turn to page number 32, my lord. This is a complete, my lord. This was the earlier monastery, my lord, constructed in 2019, my lord. My lord, has seen, my lord, page number 32. Then, my lord, page number 33. This is the statue put in there. Then, my lord, page number 34, my lord. This is the notice sent by the opposite party threatening that.
Mr. Sonar, this is, you see, in a criminal petition, when you have come for questioning of the FIR, we have to only see whether the case in the FIR is made out or not.
My lord.
Any other document which you have filed,
My lord.
That cannot be considered,
my lord,
for the purpose of 482.
My lord. Well, I'll then read out the FIR, my lord.
Because this documents is your document.
My lord.
If you can show me an authority, the other documents can be.
These are the part of charge sheet, my lord. Charge sheet also. In the charge sheet also there. My lord, I will read the FIR. Now I will confine to the FIR, my lord. Page number 30, my lord. I will confine to the FIR, my lord. May I read my FIR, my lord?
Yes, yes.
3rd August 2022. FIR against Sri Michung Kamba, petition number 2, Tendi Lamu, petition number 1, my lord. Laida Wangsu, Sri Ananta Narayan Misra, State General Secretary, BJP, and others for insulting and hurting the religious feelings, promoting enmity between communities, and creating communal disharmony, my lord. The complaint is made against the above numbers on the following grounds. The Chime Yangsan Society, under the leadership of Michung Kaba, had in year 2019 secretly constructed some structure at Eco Dumbing area, which the Simong community believes to be part and parcel of the Simong land and a very sacred place. Now they are saying that in 2019 we constructed. The Simong community strongly objected to such construction by the Chime Yangsan Society done without consulting the Simong community. Due to this, a dispute arose between the Simong community and the Memba Kamba community. Dispute arose between two communities. When the matter escalated, the district administration intervened and passed an order on so and so and so and so status quo. This order has been set aside and quashed, my lord. Further, the Chief Minister's office also intervened and had sent a peace committee to try solving the issue. Furthermore, a meeting was also called by the Chief Minister on so and so, wherein the Deputy Commissioner was advised to visit the place with stakeholder and finalize a sign for construction of guest house after consultation and taking the view of Simong community. While both the communities were maintaining peace and the matter was at rest, all these months, suddenly on 30 July 2022, it was learned that the Memba Kamba community, under the leadership of Michung Kamba, Laida Wangsa, Tendi Mumba, so and so, accompanied by one Ananta Narayan Misra, who is the General Secretary, and others, have secretly visited and constructed some structures once again at the land of dispute. It was later on confirmed through photographs posted in social media account of Tendi Lamo. Apart from being the part and parcel of Simong area, the Eco Dumbing is a sacred place for the people of Simong community having religious value. All the customary rituals and religious offering of the community is attached to it. The structure erected by them are exactly at the place where the offerings are made and from where the plants and herbs that are used during the offering is collected. These facts are well known by the Memba Kamba community. The act of the above named people have annoyed and provoked and enraged the whole Simong community of Upper Siang district. They have also aggravated the dispute by constructing such structure deliberately at the place which is considered sacred by the people of Semyon community, they have insulted and hurt the religious feelings of the Semyon community, which is an offense under section so and so. Further, being aware of the dispute and controversy between the two communities, on knowing that their activities in the disputed area may bring peace, their act of secretly intruding into the disputed land and erecting structure is promoting enmity between the two communities and creating this communal disharmony. They have committed an act which is prejudicial to the maintenance of harmony, different religion community, and which is likely to disturb peace, which is so and so and so and so. Well, this is that. Now, my lord,
Just a moment, who is the APP here?
PP.
You're there? Okay. You have the case diary with you?
Lordship, update
Please
case.
pass it on.
It is already charge sheeted, Lordship.
Hmm?
It is charge sheeted, Lordship. As per the case diary.
Already charge sheeted, my lord.
Charge sheeted when?
It charge sheeted on 16 to 2024, after during the pendency of the.
After charge sheet, what will be the status of the FIR?
Lordship, as per the charge sheet, Lordship, it is FIR, Lordship, it is the statement, Lordship, corroborated with the allegation made in FIR, Lordship. The witness statement is also there, Lordship. And also, moreover, Lordship, this, as per your Lordship note, the Niharika infrastructure, Lordship, versus State Mazda, the pendency, Lordship, cannot be, pendency of the Lordship, this investigation and the trial, Lordship, is stage, Lordship, court has not been interfered, Lordship. Let the matter, Lordship, decided by the Lordship on the own merit. Because Lordship, here, Lordship, the allegation, Lordship, that is being sanctioned order, Lordship, that the petition number 2 has not been accorded with the sanction order. That is their Lordship. Otherwise, his name is already reflected in every statement of the witnesses, Lordship.
Okay, that's all. Yes, that will hear you.
Lordship.
Yes, my lord. I will.
No, that's all.
My,
Since we got this police report. Yes, we'll hear you, then we'll hear Ms. Danjan.
My lord.
We'll hear you first.
my lord, I,
No, we'll hear you first, then we'll hear.
my
you.
lord, I will make 2-3 submission.
No, we have seen that, because since the report is there of the
Only
police.
2 point, my lord. Here issue is basically, my lord, I am not disputing, I have not constructed. This is page number 66 of the charge sheet, my lord, my additional affidavit, my lord. Kindly see, just I will finish it up, my lord. Page number 66 of my additional affidavit, my lord. This is the charge sheet, my lord.
66.
Yes, ma'am.
66 of additional.
Additional affidavit. Bringing on record the charge sheet.
Page number नहीं है. Numbering नहीं किया है. Internal page number
66, my lord. 66.
yes.
My lord. This is the photograph which petition number constructed, my lord. And for constructing this one, only this FIR has been filed. This is for, my lord, in place of earlier monastery, my lord. When the pilgrimage comes for staying, my lord, this was constructed. My lord, kindly, then thereafter, my lord, page 68, my lord. My lord, this is the, my lord, earlier monastery which was put to fire, the remains of the earlier monastery, my lord. Page number 68, my lord. This is the not my record, part of the, my lord, police record, charge sheet, my lord. Then, my lord, kindly page number 69, my lord. Then, my lord, page number 70, my lord. My lord, question is now, my lord, page number 70, my lord. This is the which I constructed, my lord, and for which FIR has been filed. Now, my lord, what I beg to, my lord, submit is, my lord, like this, my lord.
Yes, please continue.
It is, my lord, not in dispute. It is on the record, my lord, that earlier there was a monastery that was put on fire, completely dismantled, my lord. Thereafter, I constructed a small, my lord. My lord has seen what I have constructed, wooden sort of thing, so that people can rest, my lord. It is something, my lord. If somebody is having a temple in a mountain area, somebody miscreants comes and completely damage. And if I go next day, my lord, and if I construct a temple there, my lord, can it be said, my lord, I have committed a offense of, my lord?
That is something we can't answer.
My lord, this is, my lord, this is exactly the case, my lord. Now, my lord, this is basically the case of land dispute, my lord. This is the case of civil nature, my lord. Now, ultimately, a competent civil court will decide, my lord, who is the actual owner, my lord. So, my lord, there is nothing, something, my lord, which even so, my lord, forget about, my lord, non-cognizable offense. Cognizable offense. No offense prima facie discloses, my lord. How this can be, my lord? This is the on the record by the prosecution also.
This is whose organization? ANYA.
My lord, which one, my lord?
Organization called ANYA. Who is? This is an organization of whose side? Petitioner or the respondent?
Organization. That part we don't know, my lord.
ANYA.
All PEMA code.
I don't know, the full name is not there.
Our is, my lord. Or A is not all PEMA code Youth Association. APYA, my lord. APYA.
ANYA.
No M, my lord. AM. No idea, my lord.
Who's tagging Bangang? TAGING tagging Bagang BAGA.
My lord, this is of the different community.
Nothing.
Nothing. They are not in a dispute.
They are not
in the dispute. It's, my lord, this issue is between FIR laws by President of Simong and Himong Community Youth Association, my lord, and against this PEMA Court Welfare Association. Now, my lord, this is a civil dispute, my lord. My lord, land dispute, my lord. Now, by constructing on the same place, if a monastery, my lord, where earlier was existing, my lord, and they have destroyed it, my lord, demolished, my lord. It is on the record, my lord, Now, my lord, for that, my lord, my intention, is it my intention, my lord, to create enmity between them, my lord? Not at all, my lord. It is something, my lord, essential for the pilgrimage time, where the people will take rest, my lord. That is the thing, my lord. That's why, my lord, civil matter is pending, my lord. This is
I'll take some rest and then come back. We'll hear Miss Hage.
Lordship.
But we have the police papers. You see that. Yes, I think your only submission would be that charge sheet has been submitted, therefore police form prior to the materials.
Lordship, here, Lordship, the statement of the Lordship, petitioner one, Lordship, in the page 39, Lordship, of the affidavit position, Lordship. Additional affidavit of position.
Page
39, Lordship.
39.
Yes, Lordship. And the statement of any accused, Lordship, that is in this petition, Lordship, petitioner one, Lordship.
Just. Yes.
May I, Lordship?
Yes.
Lordship, here, Lordship, her statement is that I am this day being asked that I am a businesswoman presently staying at the Ganga Vivekananda. I am president of Pemakot Youth Association. There was no any formal informal meeting conducted for the construction of Gompa. The structure, namely one log cabin, this was led by me and Sri Sonang Phungso, General Secretary, State by Sri Miching Kamba, President Chime Yangsang Society. Except for the presidents, no one at the executives of Chimbe Yangsang Society have knowledge of construction of Gompa at Reotala, since no any formal or informal information has been given to the executive members. Also, there was no financial assistance from Chimbe Yangsang Society. All the expenses were borne by youths. My total expenditure was 2 lakhs during the budgeted touring, although the total amount was not used for the construction. I went to Reotala under the care of my uncles, namely Sri Mahung Singhi, Sri Machung Wagang, Sri Tayam Bagan, Mese Bagan, and Aunt this is Losip. It took 2 days to reach the hotel and return to Tuting on 25/7/22 with accompanied parties. Michung Kamba went till Singa and did not reach the hotel due to the health issue. Sri Ananta Narayan, General Secretary, BJP, Anuja Parjat, informally visited the hotel on being invited by Sri Michung Kamba. I am also verbally invited him since we have close relations. Once Sri Leda Wangchu, along with his wife, Srimati Ari Nangu Visa Reotala. There were around 40 to 50 people. Sri Ananta Narayan Visa has been invited by Sri Michung Kamba. He has no prior knowledge that the land is disputed. He was only informed that last year some unknown miscreant damaged the Gompa Reotala. This much I have tested. Lordship, put some questions, Lordship. Do you have any knowledge that the place is disputed, Lordship? Then that petitioner one has given the answer that yes, I am fully aware of it. In this regard, we have submitted a representation letter to Honorable CM that were against the 4-point decision. Why did they for the entire Lordship? Here, Lordship, she is admitted that Lordship that he is fully aware of it, Lordship, that the disputed part, Lordship. Even though they have Lordship carried forward that construction of the Lordship. It is Lordship, prima facie is reflected that they have Lordship, intensely Lordship, had erected that Lordship, whatever they had tent or whatever Lordship, their motive was something else, Lordship. That's why Lordship, the charge sheet was Lordship already is submitted, Lordship. There is a prima facie material Lordship against them. As well as Lordship, witnesses statement also been recorded. So Lordship, let the matter maybe Lordship, trial may be conducted, Lordship, fairly, Lordship. So in this stage, Lordship, Honorable Lordship has not to be interfered, Lordship. That is my submission. Obliged, Lordship.
Yes.
May I please, Your Lordship. First of all, Lordship, the submissions made by my learned friend regarding the land dispute and all those documents, those are not part of the charge sheet. Those are not part of the charge sheet which has been submitted, number one. So those are things which he may take in defense during the trial, maybe. Another thing, Lordship, I would like to point out that since he has gone into the history and all, prior to 2019, there was no dispute at all. His case, if we hear from his side, it amounts to saying, I have my religious beliefs are better than yours, so you don't have right to say anything. Because, why I'm saying this? Because this is a place, this is a sacred place for Simong villagers for people coming from Simong village, there are 8 villages in the whole of, starting from Simong onwards till Tuting. They perform religious rites. They perform some rituals there every year in the month of January. In the after March, they perform some rituals, which has not been mentioned in the FIR, but that is why it is written in the FIR. There are religious beliefs and rituals and all. Those are performed every year, and there are some particular herbs, particular things which is from that place only. So they take it from that is called Jihang festival. When the Jihang, before Jihang, every time the Simong villagers, not only one village, 8 villages go there. And it may sound bad if I say this, but most of the people who have now built a Gonpa have come from Tibet. The original settlers are the Adi tribes which have settled there. So that is why, but it is also true that that land has also been used as a pilgrimage by them. But the land was never disputed ever at any point of time from their side. It's only in 2019, then when they built the Gonpa, they gave a notice to these people saying, don't build a Gonpa, we remove it. That they have already said notice was given. In the notice, your lordship will see at page 34, the Simong villagers gave a notice to them saying specifically, lordship may see page 34, saying specifically, we are the absolute owners of the area. Para 2. It has been found that while doing so, your community has never sought permission from the people of Simong community who are the absolute owners. Now, in reply to this, they have made a reply to this at page 37. At page 37, what they have said? They have not said you are not the owner. They have only said, let us maintain status quo. We are brothers. This is what they have said. In paragraph 3 of that page 37, this is the reply to the notice. They have said, in the year 2019, our community has constructed a log cabin for Gonpa Kam staging bath with kitchen, adriotala, purely for religious pilgrimage purpose, and there is no any hidden ulterior motive. Your lordship will see, will read the whole page. There is nothing which disputes that you are not the owner. We have a separate claim of ownership. That is not there. What they are saying is, kindly let us maintain status quo. And they are saying that every year since we visit, so for this thing, log cabin was constructed. They've admitted that it's only in 2019 that cabin was constructed. Of course, thereafter, there were so many problems which arose there. Some miscreants had destroyed it, and like what you said. So the history of the case is clear that there was high tension in the area, because they are saying after the Simong villagers, there was an allegation against the Simong villagers that they had destroyed the Gonpa and all. Because of that, FIR was lodged. Then so many things happened. In those in such a high tense situation, can they say that that because this is our land, there is no problem, there is no land dispute, then we can build our land? Because section 295A and 295A2 and 153A
is the religious rights of both sides
yes
documented anywhere? Any historical document?
Historical, that I'm not aware, but it is a practice. Everyone knows that in that area. What I'm saying is, lordship, given the situation, given the tense situation, even in my learned PP has read out the statement. She has said that I'm aware of the dispute. Now, can you say my God is better than yours, so therefore you have no right, I have better right? You know that the other person is also claiming. In such a situation, will not building a Gonpa at that place, can they say they're not aware that such a dispute will arise? Can they say that hatred will not spread in such a situation? That is what section 153A says. Section 153A, subclause B. Promoting enmity between different groups on ground of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony. Whoever, first part I'm not reading, B, commits any act which is prejudicial to the maintenance of harmony between different religious, racial, language, and regional groups or caste or communities, and which disturbs or is likely to disturb the public tranquility. This is a fit case of Section 153A, subclause B, Lordship. In such a situation, how can they claim that it is a mere land dispute, Lordship? This also attracts 295A, Lordship, of the IPC. Attempts 295A, deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs. Whoever with deliberate and malicious intent of outraging the religious feelings of any class of citizens of India by words either spoken, written, or by any signs or by visible representation or otherwise insults or attempts to insult the religion or the religious beliefs of that class shall be punished with an imprisonment of either description for a term which may extend to 3 years or fine or with bond. So these are the specific sections under which this FIR has been lodged. Now, Your Lordship knows the law very well, that in view of the fact that they have a right to defense in the trial court, in order to allow a petition of under 482A for quashing of such a case, it has to be a very, very, very good case, which in my humble submission, it is not. So I'm relying on Lordship 2022 3 GLT 782. This is para 12 and para 15. I have given the list of books. In para 12, that famous case of Bhajan Lal has been 2022 3 GLT 782. Para 12 and 15, Lordship. This honorable court has held that when all remedies in law are available to invoke the extraordinary powers of this court under 482 CRPC, an exceptional case has to be made out.
Which paragraph?
Para 15. Para 15. Para 12 is reproduce Bhajan Lal's case. Lordship knows the parameters. Under which FIRs or proceedings can be quashed. Now they cannot say that from the FIR, no case is made out. Para 15 says, Lordship, that because alternative remedies are available, for when all such remedies are available, to invoke extraordinary powers of this court under section 482 of the CRPC, an exceptional case has to be made out. In the instant case, the burden is on the part of the petitioners. The burden on the part of the petitioners is even higher as the charge sheet is yet to be filed and charges are yet to be framed. In fact, the instant petition can be dismissed on this ground alone, that it is premature. However, this court has gone into merits also. Now, Lordship.
Yes.
Yes, I would also like to point out that the Honorable High Court's order, which had quashed the order of the DC, that is at page 44 of the petition, that was only on the ground of lack of jurisdiction. Only on the ground of lack of jurisdiction on the part of the Deputy Commissioner. Lordship may see page 40. Lordship, page 44 is the relevant portions. Otherwise, it starts at page 41. Since the Deputy Commissioner had held that the land belongs to the Simong villagers, there was a question on the lack of jurisdiction. So only on that limited point, the case was disposed of. Deputy Commissioner has not, the court has not gone into whether who should have been the owner, who should not have been the owner. page 44. It is further, the last paragraph, second last paragraph, page 44. In view of the aforesaid submissions, this court is of opinion that there is no requirement to go further into the other aspects of the dispute, since it is apparent that the Deputy Commissioner, Upper Siang, had exceeded his jurisdiction in passing the impugned order dated 4/10/2021, by which the ownership and title over the plot of land has been decided. The same is set aside. However, the parties, including the private respondents, are at liberty to approach appropriate forum for this resolution of the dispute. It is further made clear that any observations made by this court in this order shall not cause any prejudice to the interests and merit of both the parties. So this means nothing, Lordship, at least at this point. So my humble submission is, Lordship, that no exceptional case has been made out, that it is clear from the FIR that case under 153A and 295A has been made out. So therefore, this is not a fit case for quashing the FIR. In fact, quashing of the proceedings has not been prayed for, even though in the meantime, the charge sheet has been filed. Initially, the petition was for quashing of the FIR. Obliged, my lord.
My lord, sure. My lord,
Just a moment.
I will just.
Just a moment. Yes.
My lord. Well, so far, referring the petitioner as of Tibetan origin, I take a very strong objection and exception, my lord. Referring the petitioner from the Tibetan origin, my lord, I take it very strong objection because they have a ST scheduled tribe and their tribe, Memba Kemba, are recognized as a scheduled tribe of the state of Arunachal Pradesh, my lord. This is a recognized part, my lord. This is, my lord, I think the opposite party doesn't have the knowledge proper, my lord. So, leaving aside, my lord, let's come to the issue. Now, my lord, subsequent one development, that temporary structure has been again, my lord, that has been also forcefully removed by them, my lord. That temporary structure, which we constructed, for which FIR file, that has been again removed by them, FIR file.
We don't take cognizance of those things.
Yes, sir.
Because it's
saying
there is only for quashing.
Yes.
So we'll be confining
now,
ourselves.
now I will just for this quashing. Now I will put in this way. I will not go to all those details. Admitted fact is what, my lord? 2000.
Please,
from the FIR, my lord.
Please don't repeat.
My lord, no, I'm not repeating.
Yeah.
It's only I will put it 2 point that will solve my thing. I will leave to the wisdom of the court, my lord. Now, my lord, same thing. Like I will not refer even the monastery. I will say a plot of land I constructed. Forget about who is the owner even. I constructed a house in 2009. I was living there. Then all of a sudden, one other person, he says, maybe he may be the owner even. He comes in 2021, says, Mister, this is my land. You have to go out or I will remove your house. Then I said, no, this is not your land. This is also my land. Then what this guy does is like, because he's powerful, he's more people. He comes, burn, fire my house completely. Then I have no place to go. Then I said that, no, since I was in possession, I was burning, I will create a small hut. I will stay here because I have no place to go. Then this guy will say, again come, remove this one. Then he will say, okay, this is my place, as if that only his.
Please make legal
this is the
submission.
case.
Mr. Sonar, please stick to the legal submission.
My lord, this is the
stories.
case.
You see, for one story, you say I know 100 stories.
My lord, that's why I will come to
Doesn't
that.
doesn't
No.
take us anywhere.
Yes, my lord, this is the case. FIR, my lord, has seen. This is the case. What is the FIR?
We got it.
My lord.
Got it? That's why we.
Then,
stopped
my
here.
lord, my case is not, I am saying from away that I have not constructed the monastery. I am saying repeatedly, they don't need to prove also. I am saying before this honorable court also, since from the first day I said that I constructed. Is it an offense? If my lord thinks that constructing monastery in place of burned monastery, if that is an offense, then I have nothing to say. My lord, I will some citation. I have nothing to say. I leave to then I don't need to make any submission even. Bhajanlal, my lord, all the machinery is in their favor, my lord. 102, my lord, Bhajanlal paragraph. I will just read out the relevant portion.
102,
Para Bhajanlal case, my lord.
102 subpara.
Para subpara, my lord. Para 1, my lord. 102, my lord, first clause, my lord. My case will fall under, my lord, first clause, second clause, fourth clause,
First, second,
fourth, fifth, my lord. Then 7, my lord, where the criminal proceeding is manifestly attended with mala fide, or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge.
92 supplement 1 SCC.
Yeah. 1992
Supplement one.
This
SCC. Yes.
My lord. Now, my lord, I will also put very recent judgment of the my lord. It is not so 482, it is not something my lord has to just confine to the FIR, not only that. My lord, when there is question of my lord vengeance, ulterior motive, my lord can go beyond certainty, beyond FIR. Between the lines, my lord can read to find out the real thing, my lord. I will put that part. It is not saying otherwise what will happen, my lord. A person, if wants to put somebody in criminal action, he will perfectly write the FIR. Only because he is so good in writing FIR. If a lawyer writes a FIR, then my lord, you can make any, there can never be a case of quashing, because law is not saying it. We have to see beyond the FIR, between the lines. I am coming on that. 2023, 8 SCC.
Page.
2023, 8 SCC, my lord, page 734. Para 9. My 9, 10, and 11, my lord.
Yes.
Para 9, my lord, may I read?
Yes.
At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under Section 482 of the Code of Criminal Procedure or extraordinary jurisdiction under 226 to get the FIR or the criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous, vexatious, or instituted with ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and a little more closely. My lord has got the para 9, my lord. Then 10, my lord. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, then he would ensure that the FIR complaint is very well drafted with all necessary pleadings. The complaint would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR or complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. Then para 11. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under Section 482 or 226, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation, registration of the case, as well as the materials collected in the course of the investigation. Take, for instance, the case on hand. multiple FIRs have been registered over a period of time. It is in the background of such circumstances. The registration of multiple FIR assumes importance, thereby attracting the issue of wreaking vengeance out of personal or personal grudge as alleged. What am I saying? Well, that we lodge one FIR against them. Nothing happened. Then is otherwise, otherwise, even in this case, even if we read only that part, even no offense is made out, no cognizable offense is made out. Now, other part, those who are on the record, only two parties only there. Old monastery burned, in that place of monastery I constructed. If that will whether come under 153, 253 or something, whether I intended or whether that was built in place of earlier place so that we can go for the pilgrimage site. My lord will has to look to that aspect only. With that, my lord, I conclude, my lord. Much obliged.
Ms. Hage, under which volume of the Arunachal Pradesh Code we will find any notification or order requiring permission from the Deputy Commissioner or any other authority to visit that place? Supposing I want to go to Zero. Or let us say I want to go to Pasighat. Under which law I am required to apply and take permission to visit that place?
Lordship,
I'm speaking of inner line permit. Apart from inner line permit, supposing I want to go to visit any place of interest, where is the requirement of permission from the government or any authority to visit that place.
Lordship, that is lordship up to the lordship. If they have visiting lordship for the for personal lordship purpose, then it won't be required lordship. If you are invited lordship, then
No, I'm not invited.
or lordship.
Nobody invites me. I'm a bad man.
And lordship.
Nobody invites me.
Lordship, in other permits is there lordship, then
Except
it
the times the bar would be welcoming me. Apart from that, I have no one likes
no
me.
lordship. If personal visit, it won't be required lordship. If inner permits there lordship, yes lordship.
Okay. So please think over and tell us, because this is a statement which we will record in the order.
Lordship.
Please think over,
Lordship, ex parte lordship, here statement lordship, one of the witnesses statement, there is reflected that they have some permission they have to be
So
sought,
if-
but
that's why
yes
I'm
lordship.
asking you,
Lordship,
if-
maybe that
if there's a
permission,
permission
because
required-
it's disputed area lordship, that
No, no,
maybe
understand, even for disputed area,
Yes,
let
yes.
us say I want to visit, a very big fight is going on in some place, disputed area.
No.
I know that tomorrow the matter will come to the High Court. And therefore, before that matter comes, I want to visit the place, have an idea of what is happening. That's why I read newspapers.
lordship.
In newspaper, maybe I'll find some news. And tomorrow there will be a bail petition.
No.
Correct. So the intention of reading a newspaper is to get me acquainted with the knowledge. Now, therefore, there is a dispute, and I intend to visit the disputed area. Now, under which law will I find a notification or a coded law
No lordship, it is
which requires a permission to be taken if the area is disputed?
lordship, if the disputed area there lordship, if it not been granted a permission lordship, that permission may be sought by the deputy commissioner, but this
No, no,
yeah.
maybe is something else.
No,
I'm
sir.
not on maybe. You see, I as a citizen, am supposed to know law. Correct.
No, sir.
Although judge is not supposed to know law. There's an exception. There's a particular provision which requires that the judge may not know a law. But as normal citizen would be required to know law. Are you aware of that provision? No.
No lordship, I have not aware
You're
lordship.
not aware.
No lordship.
So then spend some time reading books. That's why people don't like me. Evidence Act. Oh, something. It's a beautiful exception, and I'd never allow me to forget it. No, I'll give you the book. Don't worry.
Yes.
Don't accept pressure. Yes. You see 57.
Lordship.
Correct.
The effect of which the court must take judicial notice lordship.
Now, end of the, you omit all this, there are 13 clauses. Omit all those 13, go down, I have tick marked.
Yes, lordship. If the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produces any such book or document as it may consider necessary to enable it to do so.
So you tell me that there is an offense under 144 CRPC.
Lordship.
I may not choose to understand that unless you produce the document and tell me that this is 144.
Lordship.
Correct. So
Yes,
therefore, a judge has an exception. He does not need to know law.
Lordship.
So therefore, I don't read law. Correct.
Lordship.
I only read that and stop. I don't know the other law. That's what I'm asking you. Now, if I want to go to a disputed place, where is the requirement of any law that I would have to take permission? Please choose, and if you want, you can go out and take advice and come back.
Hmm.
But this is something which I'll record in the order.
Oh.
So we take 5-minute break and come back.
Lordship.
Any requirement of law, either codified or by way of a notification, requiring that permission of the administration is required to be taken before you visit, anybody visits a disputed place.
Lordship, this is very essential because this in this matter, lordship, the issue is there, Lordship, as the Lordship have rightly pointed out, Lordship, because Lordship, as per the Lordship, this FI Lordship, they have tried to Lordship intervene, Lordship, where the disputed, this already disputed place,
That's
Lordship.
why I'm saying it will
Yes,
be very
Lordship.
important. I'm
Yes.
that's why giving you time. I'm not in a hurry to report your statement
Lordship.
immediately. Please consult someone and tell us, is there any such rule? Because then what would happen is very easy, because that law is not prevalent in Assam.
Mhm.
Therefore, two people will fight over a house, and then without even requirement of 144 CRPC to be imposed, nobody will visit that place.
Lordship.
Correct.
Lordship.
So somebody wants to oust you from your own home. He just has to go into the home, your home, beat you up, throw you out of the room. And once it's a disputed place, even you can't go, I can't go. So only one question for you.
Yes.
Correct. Come back after some time. You can take advice. In the meantime, I'm reading this, your status report. Okay. You have heard Mr. Harasunar, learned counsel for the petitioner. Come on, this L Hager and APP appearing for the state, and Miss Anne Angel and a counsel appearing for the. There are two petitioners for the respondent numbers 2 and 3. Next para. By filing this application under section 482 CRPC, the petitioners have prayed for quashing of the FIR dated 3/8/2022, registered as Yingkyong, YINGKIONG, police station case number 29 of 2022 under sections 120 capital B, /153 capital A, /295 capital A, /34 of the Indian Penal Code. Next, at the outset, the learned counsel for the petitioner has submitted that during the pendency of this criminal petition, the competent authority, i.e. the Joint Secretary within Home, from a government of Arunachal Pradesh, by a letter dated 27/12/2023, granted prosecution sanction only in respect of the petitioner number 1, namely Miss TENDY number LAMBO, and not against Sri Michung, petitioner number 2, namely Sri Michung, MICHUNG, Khamba, KHAMBA. Full stop. Consequently, the IO of Yingqiang PS case number 29 of 2022 has forwarded a charge sheet bearing number 1 of 2024 dated 8/2/2024 against the petitioner number 1 and 2 others, but not against the petitioner number 2. Full stop. This fact is not disputed. Either by the learned APP or by the learned counsel for the respondent numbers 2 and 3. Full stop. Next paragraph. Mr. Sunat, please pass on that 2023 case. Yes. So now why are you replacing this judgment? It goes against you.
No, my lord, only to the point,
No, but if I read the judgment,
my lord.
I read the entire thing. I had to read the entire judgment from paragraph 1 to the last
My lord,
paragraph.
I have understood. My lord. No, only to emphasize only one point. Whenever, my lord, this FIR is filed, my lord.
No,
And
no,
when,
here you see,
my lord,
that's why I had to read this entire paragraph,
Yes.
this judgment.
my lord. Here, my lord, there is that case, my lord.
That submission would not fit in. The reason is
My lord.
that in this case, the Supreme Court took notice of a fact that after the change of government, 30 criminal cases are filed against the petitioner. And there is a observation here that once the petitioner gets a bail in one case, then another case is instituted against him. So it is under that fact that the Supreme Court says it has referred to that observation, but that observation, even the Supreme Court is not following it. And it says you go and file for a discharge. So if you are giving us a citation where the Supreme Court, after taking cognizance of 30 cases and demolition of 3 buildings of the petitioner, sorry, this is appellant by the government after the change of government, it still sends the matter back for hearing on discharge.
Yeah, my lord. There, my lord, this investigation was in that case only for my lord. This is that case. Facts,
No,
but
please
what
tell
is
me.
why I am
This is
emphasizing
an
that
observation
point.
which within the Supreme
It's
Court
like
in this
my
case
lord,
is not followed.
only to bring on the point that my lord, while exercising 482, can look into the circumstances, not for other purpose. Can
This has
look,
to be
my
read-
lord need not to only see that, only to, is not restricted to the FIR only.
This
My
has to be
my
read in the
purpose is that
constitutional
my lord
justice.
is free. My lord is at liberty to look into the circumstances, under what circumstances the case has been instituted, not for otherwise, my lord. And otherwise, my lord, what will happen by my lord? Only if I confine to the FIR only, without looking, taking in the circumstances. My purpose is only, my lord, that my lord can look into the circumstances. Only for that purpose.
By referring to the decision of the Supreme Court of India in the case of Iqbal, IQBAL, alias Bala, BALA, and others, versus State of Uttar Pradesh and another, comma, within bracket 2023, bracket was 8 SCC 734, comma, it is submitted that that in a case where frivolous and vexatious proceedings are brought to the notice of the court, comma, the court in exercise of jurisdiction under section 482 CRPC need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation or registration of the case, as well as materials collected in course of investigation. First off, with support of the said decision, comma, it is submitted that the place where the incident took place is claimed by the petitioner, the petitioners, as a community land. Full stop. It is submitted that the area is a mountainous area, and till date no person has been granted what is the LPC full form? Land Position Certificate.
Land possession certificate.
Land Position Certificate within bracket LPC for short. Full stop. The petitioner admits having constructed a monastery at at a particular site, comma, claiming it to be a site of religious importance for them, and they have installed a statue of Lord Buddha. Full stop.
Abalokitesvara. This is a name of
Please
statue.
write it down.
Yes, madam. I'll give.
Please write it down. Which is known as, which is popularly known as so and so. Full stop. Next paragraph. The learned counsel for the petitioner has also referred to a notice dated 5/9/2021 issued by five Gambura, no, five, no, eight Gambura of 8 different villages in the adjoining area.
Simong villages, not. Although there are 8 different villages, they are all known as Simong. In as much they come from Simong. Simong villagers.
What is the spelling?
Simong.
Simon
G.
G.
Yes.
Collectively known as Simong village.
Yes.
Simong, Simong village. To project that the Gamburas had asked the addressee I. Sri Michung, Michung, Khampa. Michung Khampa, who is he? Petitioner number 2.
Yes.
Huh?
Yes, madam.
Petitioner number 2. As president of CHEME, Yangchang, YANG, CHANG, Welfare Society, Tuting, TUTING, to remove all erected structures from EKO, Dumbing, DUMBING, Dumbing area by 30/9/2021. And they were, and the petitioner number 2 was put to notice that in the event of refusal or failure to comply with the notice, the structure will be removed by the people of Simung community.
In the, sorry, Lordship, in the notice at para 4, it was apprised to them that this is a sacred place for Simong people also, and that many rituals and offerings are attached to it.
That's okay.
Yes. They're put to knowledge about this.
Simong community, and that apart, necessary action shall be initiated against you as deemed fit and proper. Full stop. Next one. To give the background of the interstate dispute between 2 communities, it is also submitted that on 4/10/2021, the Deputy Commissioner, which district, Upper Siang District, declared ownership of the land in favor of Simong, SIMONG community, and accordingly the said order was put to challenge by filing WPC 374 of 2021. Where is that order? Which page?
Page 42.
42. And this court by
Start
order
with page
dated
42.
9/6/2022, on the jurisdictional point, held that the deputy commissioner was not vested with the power and jurisdiction to make any finding on the title of the land. And accordingly, the order dated 4/10/2021 was set aside by giving liberty to the parties to approach the appropriate forum for resolution of the dispute. Full stop. Next paragraph. In the meanwhile, Kawang decision was made in favor of the Simong community, which the learned counsel for the petitioner claims to be an ex parte decision against which an appeal has been preferred, which is pending before this court.
My lord, now it's on like from here, my lord, on the point of limitation, that was civil appeal was dismissed, then revision allowed from this honorable court, remanded back to the district judge Pasighar, directing him to transfer the case to the jurisdictional civil judge junior division Yingkiong.
Oh, okay.
So pending before the competent
Pending before
civil
the
court.
competent court, civil court.
Yes.
Full stop. Next paragraph. It is submitted by the Land Council for the petitioner that in between 16th to 24th of October, 2021, the monastery and structures built by the people from what is your community?
Memba Khamba, my lord, two communities.
Where is the spelling? Where will I find it?
Memba, my lord.
MEMBA,
Yes.
Memba, Khamba, KHAMBA,
Yes.
community. Was burnt and destroyed. And the idol is also destroyed.
Idol, everything, man.
Okay, and in the process, the idol installed in the monastery was also destroyed. Full stop. In the FIR which was lodged on 28/10/2021, a final report was submitted by the IO on the ground that the perpetrators of crime could not be found, against which protest petition was filed. And when the matter was sent back for fresh investigation, once again, a final report was submitted by projecting that the perpetrators of the crime was not found. This the second final report is which date? Where is the date?
My lord.
Second final report, what is the date?
Final report.
It was submitted on GAP. Full stop. Under the set factual background, comma, it is submitted that when the petitioner number 1, along with some members of a community, constructed a temporary wooden structure
Charge sheet is on 3/8/2022, Lordship. Oh, sorry, 1/2024, 8/2024. Charge sheet was filed 8/2/2024, 8 February.
2024. Okay, 8/2/24. That's second FR.
Lordship, this is the Lordship, charge sheet, Lordship, 173.
No, it's okay. In his case,
Okay.
the final report in the case lodged by Mr. Sonar's client. I am asking of that.
Okay, Lordship.
The FR, he says that on second occasion, FR was submitted.
Okay.
I'm asking the date.
My lord, it's not available. I have to give. I
Okay.
will later on, my lord, I will give my.
No, don't say the date. Don't give it. Full stop. Next para. Where is this order of status quo 4/10/2021? Where is that?
Deputy Commissioner, my lord.
Yes,
My lord will find at my lord page number 39 to 40.
39/40.
That was quashed, my lord. Annexure 5.
No, my lord, it was not quashed on merits. The quashing was only to the effect that the Deputy Commissioner did not have the jurisdiction
Whatever.
to declare the
Whatever
title.
maybe, but this,
Not on merits,
this law, this
No, no,
order was
no.
not enforced.
Please don't argue with amongst yourselves. You
Yes.
address the court, we will take care of it.
My lord.
Yes.
Page number 39 and 40, my lord.
Page 39/40.
My lord.
Huh.
Operating portion, my lord, will file page number 40.
Okay.
Page 40, last paragraph. Order for status quo.
Just a moment.
Yes.
Okay, I change that word. Line. It says that it is submitted that in the order dated 4/10/2021, which is referred above, referred herein before, comma, the Deputy Commissioner Upper Siang District, while observing that the land belongs to Simong, SIMONG community, had also directed the parties to maintain status quo and peaceful coexistence has existed before the incident. I'll take a break. This. Okay. Okay. Continue at post lunch. Next one, as stated herein before, comma, at the site, no, not as stated before, just say the petitioner, the learned counsel for the petitioner has submitted that at the site where the monastery was burnt and destroyed, comma, which page is the FIR?
My lord,
Which page is the FIR?
paragraph, my lord.
FIR is at which page? 27. On
Our FIR, my lord, case number 47.
2024, no, not yours, their FIR.
My lord.
You don't. 20 or 3/8/2022, comma, an FIR was lodged by the FIR name?
Yeah, the private respondent, my lord. Asin Libang, my lord, we find it page number 31. 31. At the bottom, my lord.
Okay, by
31.
it was lodged by the respondent numbers 2 and 3. Which is registered as Yunkyong PS case number 29 of 2022. Stop. It is submitted by the land council for the petitioner that obviously the FIR does not disclose any commission of any cognizable offense. First off, it is submitted that reconstruction of the place of worship with a temporary structure which is disclosed in the documents appended to the charge sheet cannot be read to have promoted enmity between different groups on the ground of religion, race, place of birth, residence, language, etc. Or that such construction is prejudicial to the maintenance of harmony, or that the petitioner had committed any act which can be said to be deliberate and malicious, intending to outrage religious feeling of any class by insulting its religion or religious beliefs. Accordingly, the learned counsel for the petitioner has paid for quashing of the said FIR. To support his submissions, the learned counsel for the petitioner has also placed reliance on a decision of this court in the case of Apurba Kumar, APURBA Kumar, AR, Chaudhary, CHOUDHURY, and another versus State of Assam and another, 2022 within bracket 3, bracket was GLT 782. Yes, you got the information. Any such notification on the state? Is there any notification in the state?
Lordship, no, Lordship, there's
No.
nothing, Lordship.
Okay. The learned ADP has referred to the contents of the charge sheet, which is annexed to the additional affidavit filed by the petitioner on 15/6/2024. And it is submitted that the petitioner had stealthily visited the stealthily intruded INTRUDED into the disputed land and erected structures which amounts to promoting enmity between two communities. And that the petitioner and her entourage, PNTROUG, had not taken any permission from the authorities to visit the disputed site. Full stop. It is also submitted that the photographs appended to the charge sheet also discloses erection of structures. Full stop. Accordingly, it is submitted that this is not a fit and proper case for quashing of the FIR, and that the petitioner should be subjected to the completion of the trial. So it is also submitted that the competent authority has also granted sanction for prosecution against the petitioner. Accordingly, it is submitted that there is a prima facie case for trial against the petitioner. Petitioners. Next, brother. The per contra, the learned counsel for the respondent numbers 2 and 3 has submitted that as the learned counsel for the petitioner has referred to the past projections of certain religious beliefs of the petitioner, which led to the erection of structures at the disputed site. It is submitted that the community of the respondent numbers 2 and 3 also exercise their right since antiquity over the disputed land, and their tribe also performs certain rites at the site where the monastery has been submitted. Created, public constructed. It is also submitted that as the Deputy Commissioner from Upper Siang District had passed a prohibitory order it was incumbent on the part of the petitioner to take permission from the people of Simong community to enter into the disputed land, or from the Deputy Commissioner to enter into the Deputy Commissioner or Simong community to enter into the disputed land, and to take the permission of their community before making such construction. Full stop. Accordingly, comment is submitted that as the petitioner has admitted erection of the structure, no case is made out for question of the FIR. Anything which I have left out?
I have also stated that the claim of the petitioner that they were claiming that portion of land, that is not there as per records. As per their records, there is no claim of ownership at all.
Okay.
That is page 37.
It is also submitted
In reply to the notice.
that in reply to the notice issued by the 8 Gamburas to the petitioner number 1,
Page 37.
not to Miching, to petitioner number 2.
In page number 34 is
Just
the
let me
notice.
complete. You have-
Page number 37 is the reply to the notice.
No, you see, please hear us.
No, sir.
You heard us.
Yes.
What was I saying?
I couldn't get lost.
Please, no, that's why please.
Yes, sorry,
First
sorry.
and then
Lordship.
interact. The petition, the Gambura of four villages along with the petitioner number 2 and 3 others had not controverted that the land belonged to the people from Simong community. But they had sought to justify the construction of a log cabin, hut and kitchen at the disputed site for performing religious and pilgrimage. Full stop. Accordingly, comment is submitted that the petitioners have admitted the ownership of the land by the people of Simong community. That's all.
That's true.
Next paragraph.
Also that, no, sorry, no, Sim. Also that whatever he has stated is not part of the charge sheet. It's not part of the records.
But that he has already clarified. I have stated in the order.
Yes.
I did not clarify it again.
Yes. The claims it is
You have
making.
heard how I started.
Yes.
Yeah.
Obliged, Lord.
Charge sheet is something which they will say that it's not, nobody, I have not written that it is there in the charge sheet.
Yes.
Next. Before I dictate the order, I'm asking both of you, Mr. Sonar as well as Ms. Danjan, are your people ready to shake hands?
I have to take instructions on that.
Oh, please do and come back within, because I'm in the midst of dictation.
Look, there is no
You,
issue.
you know, there are two ways of looking things. When it's in a bad side, we say it is a blackmail. Correct. But when I'm dictating an order, it is called whitemail.
No,
I'm giving an
Lordship,
offer,
because-
whether your communities are ready to shake hands.
We are not having any problem. Only
No.
the thing is that civil land dispute is going on. between
No,
us.
No, that is
that's
a
why
different
when
issue.
we are-
This,
That's why we are asking, we are not asking them to compromise.
Yeah, ma'am.
We are just saying that whether these two sides can shake hands. I'm not asking that you do a compromise. I'm not saying that we'll mediate. I'm just merely asking whether the two sides can shake hands.
Lordship, we'll have to take instructions, and because this is an issue concerning not only one or two people, huge groups on both sides. So it will take time.
Okay, I
Lordship.
understand. That's
Yes.
okay. Next paragraph. Peruse the materials on record and consider the submissions made at the bar. Full stop. As it is a well settled principle of law that while deciding an application for quashing of the FIR under section 482 CRPC, the main thrust of the court would be to examine the FIR and to find out whether any cognizable offense has been made out for trial. Full stop. Although reliance is placed on the decision of the Supreme Court of India in the case of Iqbal, alias Bala and others, within bracket Supra, from the facts which appear in the said case, it appears that the Supreme Court of India took cognizance of the fact that there were 30 criminal cases against the appellant therein, at the behest of the ruling party. And a specific observation is made that whenever that every time the applicant or their family members got protection by way of anticipatory bail or stay of arrest, the local police registered other false cases against him. Stop. It is in the said context that the Supreme Court of India has observed that when the court has inherent power under section 482 CRPC. Look into the circumstances leading to lodging of the FIR when quashing is sought for on the ground that the proceedings are manifestly frivolous and vexatious or instituted with ulterior motive to for wreaking, WREAKING, personal vengeance, VENGEANCE. And to take taking, for instance, the present case where multiple FIRs were registered over a period of time, which according to the Supreme Court of India had assumed importance that which attracted the issue of wreaking vengeance out of private personal grudge. Stop. On such observations, leave was granted by the Supreme Court of India to the appellants therein to prefer a discharge application under section 227 CRPC before the trial court. Stop. In view of the observations made by the Supreme Court of India and the nature of order or direction issued, it must be held that the said ratio may not be attracted under the facts of the present case, as it is not a case where there were multiple FIRs for wreaking personal vengeance. Stop. In this case, the petitioners have admitted that the petitioner number 1, along with Rentruge, had made the construction at the disputed place. Next one. So accordingly, this said decision of the Supreme Court of India does not help the petitioner in this present case. Next paragraph. Coming to the contents of the FIR. The contents, it would be appropriate to extract the contents of the FIR. That will be page . Again, forgot what is the page of FIR?
Page 27.
27.
The actual one is at page 28 because
Yes.
others are type copies.
Okay, page 27A,
Page 20.
huh? 27A,
28.
27B, 27C. Next paragraph.
The clearer one would be page 30, 31. It's not very clear, so there's a type copy, which is a long one. It's better to see 30, 31.
Okay, 30, 31. If you can scan and make a auto order. On a perusal of the FIR, Mama, the allegation against the petitioners is that they had secretly constructed some structures at EKO, Dumbling area, which the Simong community believes to be a part and parcel of the Simong land and a very sacred place. Full stop. Therefore, the complainant do not assert their title over the disputed land. They only claim that they believe that their community believes the said area to be a part of Simong land. Full stop. The charge sheet, which contains the description of the investigation, does not disclose that the investigating officer of the case could trace out any document in the government records which declare the Simong community to be the owner of the land which is in dispute. Full stop. In this next para, in the said FIR, it is claimed that the Simong community had strongly objected to such construction. Full stop. Therefore, if the complainants could raise their protest when the construction was going on, it is unbelievable that the petitioner had entered into the land stealthily to carry out the construction. Full stop. In the charge sheet, the IO has not arrived at a definite finding that permission from the Simong community was a prior requirement without which no construction could be carried out in the area in question. Full stop. Though in the FIR, there's a reference that when the matter escalated, the district administration had intervened and an order was passed on 4/10/2021. Full stop. However, this court, by an order dated 9/6/2022, held that the deputy commissioner had exceeded his jurisdiction in passing the order dated 4/10/2021, by which the ownership and title over the plot of land has been decided. And accordingly, the parties were delegated to approach the appropriate forum for resolution of the dispute. Full stop. After that, the said order was passed on 9/6/2022, comma, the legal interpretation of the order dated 4/10/2021 would be that the prohibitory order in favor of the respondent number 2 and 3 or any other member of their community prohibiting entry into the disputed area was also quashed and set aside. Full stop. Therefore, on a strict legal interpretation, there was no prohibition operating against the petitioner to have entered into the area. Full stop. Full stop. As for the FIR, the complainants came to know on 30/7/2022 that the members of MEMBA, KHAMBA community under the leadership of petitioner number 2 and the petitioner number 1, accompanied by some other persons, had visited and constructed some structures once again. Full stop. This necessarily means that there existed a structure on which a fresh structure was created. Full stop. The photographs appended to the charge sheet discloses existence of an old structure which the learned counsel for the petitioner claims to is a part of burnt monastery, and where the statue of Lord Buddha was seated. What do you call, what is the right word? Is placed or seated. What do you say in your language?
My lord, that statue.
Statue is placed.
My lord, statue was placed in the monastery, Gompa.
No, I understand, but what is the right word to say that the statue of a god is placed?
Goddess.
Placed, it is, do you have some technical terms of that? In Hindi, you see, I come from a community where we say that Murti is thapit.
Yes.
I use the word, in my community, we use the
English word consecration.
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 Creation.
Yes.
Was consecrated.
Yes.
Okay. Full stop. In the charge sheet, the investigating officer has referred that no permission was taken to visit to go to the area. Full stop. It is in this context that the court had specifically asked the learned APP to seek instructions as to whether there exists any law in the state of Arunachal Pradesh or any other order or memorandum or notification which requires resident within the state of Arunachal Pradesh to seek permission to go to another place. So, except for the inner line permit which is required, which is applicable for visitors who are residents of outside Arunachal Pradesh. It has been submitted that there is no such requirement of law requiring a prior approval from any or permission from any authorities to visit any site for ordinary residents of the state of Arunachal Pradesh. Stop. Next problem. In the aforesaid context, there are two eventualities. There are two ways to look at the issue. Number one, both sides claim that they perform some religious rites at the place. And both sides claim that they have been doing so from antiquity. Stop. On a query of the court, both sides have submitted that the practices being followed is not documented in any government record. So stop. If we force it to two aspects, comma, as the investigation carried out so far reflects from the photograph that there existed a place of worship of the petitioner on which she admits making construction, comma, a recreation of a burnt structure cannot be said to be an illegal act under any law for the time being in force. Full stop. Next one. The allegation in the FIR is that the structures made by the petitioner are exactly at the place where the offerings are made by the people of Simong community. And it is also projected that plants and herbs which are used during the offering is collected from the said place. Full stop. Full stop. We fail to understand from the contents of the FIR that how a construction at the place where certain rights are created would create disharmony between two communities. Because there is no attribution of any act or deeds. By the petitioner, which promotes enmity between two different groups on ground of religion, comma, race, comma, place of birth, comma, residence, comma, language, etc. Or such act was prejudicial to maintenance of harmony, comma, which are essential ingredients of an offense under section 153, capital A of the IPC. Full stop. It is not a case of the petitioners that by the construction of a monastery, comma, the petitioner or others have insulted the Simong community in any manner. It is not a case that the petitioners comma, differentiated with the respondent numbers 2 and 3 on the ground of religion, race, place of birth, residence, language, etc. Full stop. It is not uncommon in any developed world where a particular religion is followed by the state, comma, the religious structures of other communities do not exist. Full stop. No, not full stop, comma, save and except few countries which follow the communist ideology. Full stop. Next paragraph. Therefore, it would be relevant to now quote the provision of section 153 capital A of the IPC. Next paragraph. From the text of the provision of section 153A IPC, comma, none of the ingredients of clause A, B, and C of subsection 1 of section 153A is found to be attracted, even by implication. Full stop. It is not the claim in the FIR that the religious structure or kitchen, etc., was constructed for carrying out any activity to train, to use it for training, for use of criminal force or violence against any religious, racial, language, or regional group or caste. Full stop. It is also not the full stop. Next paragraph. The FIR also discloses that it is only on 30 July 2022 that the petitioners came to know about the structure. And it is claimed that the petitioners had stealthily entered into the land to make such construction. Full stop. This is also indicative of the fact that the area is usually or sparsely is very sparsely populated. Full stop. Had the area been populated, comma, the community would have come to know about the entry of unauthorized persons into their community land. Full stop. The photographs appended to the FIR, charge sheet, does not disclose any other habitation in the area of focus of the photograph. Full stop. Next one. It is also noted that it is not the case of the complainants in the FIR that any act within the meaning of section 153 capital A was committed in any place of worship or in any assembly engaged in the performance of religious worship or religious ceremonies. Full stop. Therefore, the court is constrained to hold that no ingredient of offense under section 153 capital A could be read in the FIR FIR sought to be quashed. Next paragraph. In context with the offenses under section 295A, comma, the said provision is quoted below. Next paragraph. From the text of the FIR, which is already extracted above, comma, the court is unable to find that the petitioner, that the informants would demonstrate in the FIR that the act of construction of a place of worship with kitchen, etc., was with a deliberate and malicious intention of outraging the religious feeling of any class of citizen. Full stop. There is no allegation that any words, either spoken or written, or any signs visible by representation or otherwise, was made by any of the petitioners to insult the religious group of the complainant, or to insult the religious beliefs of that class. Full stop. Under the circumstances, the court is inclined to hold that no offense has been made out under section 295 capital A on a plain reading of the FIR. Full stop. Next para. It is not the case of the complainants that while they were performing any religious acts, they were disturbed by the petitioners in performance of their religious rites, or their essential community rights. Full stop. Next column. Now the it is required to be seen as to whether any offense within the meaning of section 120B of the Indian Penal Code can be culled out on a plain reading of the FIR. Stop. To understand the purport of section 120 capital A of the CRPC, of the IPC, the said provision is quoted below. Next paragraph. Therefore, from the above, to attract the act of the petitioner towards criminal conspiracy, it is required that the FIR should disclose that two or more persons had agreed to do or caused to be done an illegal act. Full stop. In this regard, the state has not been able to produce any law for the time in force, which includes acts, rules, notifications, or other directives issued by a competent authority declaring that the act of making a temporary construction of wooden logs for a place of worship is an illegal act. In respect of the situs where such construction is made. Full stop. The other ingredient of attracting section 120 capital A of the IPC is that even when such an act is not illegal by illegal means, such an agreement is designated a criminal conspiracy in terms of the proviso appended to subsection 2 sorry, clause 2. Full stop. We are unable to agree with the proposition made by the learned counsel for the respondent number 2 and 3 that the constructions so made by the petitioners is an illegal act, or that the agreement between the parties to make such construction can be construed to be a part of criminal conspiracy, or that there was any criminal intent ingrained in the carrying out of construction of a monastery, a temporary religious structure. So therefore, under the facts and circumstances as narrated in the FIR, comma, no offense under section 120, capital A has been made out. To stop these, the aforesaid observations of the court would also apply for in respect of the offense of section 34 for with which the petitioners are charged in the FIR. Full stop. In this regard, the provision of section 34 IPC is quoted below. Full stop. The essential ingredient to attract the offense of section 34 IPC is that a criminal act should have been done by several persons in furtherance of a common intention. Comma, if the, in this regard, the court is inclined to hold that if the act of making a religious structure is not a criminal act, it is not the case of the petitioners, sorry, the respondent numbers 2 and 3, that such construction was made in violation of their documented ownership right over the land in question. Comma, the construction of such structure cannot be held to be in furtherance of a common criminal intention of the parties. Full stop. Therefore, comma, when this court had passed an order dated 9/6/2022 in WPC 374 of 2021, by which the Deputy Commissioner's order dated 4/10/2021 was quashed, and parties were granted liberty to approach the appropriate forum to resolution of dispute. Full stop. Such resolution of dispute, if it results in declaration of title of the complainants over the land in question, it is at that point of time they can exercise their right to have the structures created on the said plot of land removed. Full stop. Next paragraph. Till then, it cannot be said that the structures which are created on the land in question, which is still a disputed property, is illegal by any means. Full stop. Next paragraph. It is not the case of the state that there is a requirement of obtaining a prior permission from the district administration in the upper Siang district for setting up a monastery. Full stop. Therefore, in the absence of any law to regulate such construction, the state administration cannot just identify a religious structure to be an offending structure, because that principle would apply on each and every construction which is being made in the entire district if such construction is without any permission. To stop. In fact, for the state to insist that a religious structure would require permission appears to affect the right of a citizen to profess such religion as he desires to, he or she may desire to profess. Stop. Therefore, it not being a case of the state that construction of religious structures are banned in the Upper Siang district, or for that purpose, any construction without permission is banned. The constructions so made by the petitioners cannot be held to be illegal in any account. Stop. Next paragraph. It is clarified that the observations made above is not with an intention to create any right of the parties, but it is only to enable the court to ascertain as to whether the construction can be said to be unlawful or a part of criminal conspiracy which attracts criminal prosecution. Stop. Any inadvertent observation is not intended to create any final right, title, or interest in favor of any of the parties. Because as indicated above, by an order dated 9/6/2022, the parties are at liberty to approach. So 982 in WPC 374/21, the parties are at liberty to approach the appropriate forum for dispute of resolution of dispute of title over the land. Stop. Next one. In view of the discussions above, the court is inclined to observe that the plain reading of the FIR does not disclose any offense being committed by the petitioners, which can be punishable under section 120B, 153A and 295A, related to section 34 IPC. Resultantly, the said FIR in which the IO has submitted charge sheet number 1 of 2024, dated 16/2/2024, stands quashed. I am on record, and therefore I am saying it with all responsibility, taking the matter. I can withhold the signature in the order till 10:30 in the morning. If you agree to shake hands and for an amicable resolution of disputes, because once I pen it down, then you know what is going to happen. That's why I made that offer earlier. In the presence of all the learned members of the bar, I again reiterate, although I have dictated the order, at 10:30 tomorrow, there is a likelihood of an alteration in the order, subject to condition that both of you agree to shake hands.
My lord,
That is what I mean when I said that one circumstance is a blackmail, the other circumstances is a whitemail, because this will be typed in a white paper. So this is not a blackmail, but it is a whitemail. Now it depends on both of you and your wisdom and your ability to convince the parties as to whether there can be a handshake.
my lord, since the parties are not only one person, it's a whole
No, I understand,
organization.
but you see, I have dictated the
They
order
have
of the
to,
court.
they
The
discuss
reason for
also.
dictating, you see, the reason of dictating the order is that that is the view of the court.
Yes.
Correct. But as religious and the tribal practices are at issue, I'm making this offer so that if the parties can shake hands, then I don't have to say things which we will have, both of you will have a very hard time, even in the civil court to adjudicate. It will take years and years of litigation. But I can't wait for long. It's a dictation made in open court. The relaxation can only be made with consent of both of you. Because ideally it would be incorrect to change the dictated order. Therefore, I am on record. I am online. It's a live telecast of live streaming of what I am saying. With all responsibility, I am saying that I can still modify the order at 10:30 tomorrow, but not beyond. You may have difficulties. I'm not saying that you must go it. You have your difficulties. I understand. You are only a counsel. It will be the decision of the community whether they can take it or not. I fully follow it. But beyond this, I can't do anything. And you know that.
Obliged.
Since we have this status report, let me have this review. Please take it tomorrow.
No, sir. Right.
My lord, I'm preparing for respondent number 6 and 7, my lord. In fact, my lord, my lord, after the filing of this contempt petition, my lord,
Yes.
and the council engaged by this respondent number 6, my lord, was different, my lord. He left, in fact, the profession. Now he's joining, of course, my lord. Now, in the meantime, I have been engaged, my lord.
No, there is some order where your name is reflected. That's why we are calling you.
My lord.
For 6 and 7, I think you had appeared.
Yes, my lord. These are the newly implemented respondents, my lord. 6 and 7, my lord.
Pardon, I did not get it. Please repeat again.
The 6 and 7, they have been implemented recently, my lord.
Yes.
And after their implementation, my lord, I was instructed to appear
yes.
on behalf of them, my lord.
Yes.
And since, my lord, a copy has not been served to me, my lord, I have requested my friend to serve the copy of the contempt petition, my lord. Though it was served to the earlier counsel, my lord,
No, in
he has
fact,
not handed over me the brief, my lord.
my lord, may I just clarify, my lord.
No, I don't know. You see, copy is copy. You either give it or you don't.
No,
give
we
it.
have served, my lord, because other counsel was
No,
appearing.
I'm not interested in other counsel. You
That
see,
is why, my lord,
I
that day
told you,
also I have
when I read it, I read it thoroughly. Otherwise, I don't read it. 21/5/2024, the order says, Mr. D. County Learned Counsel appears for the respondent number 67 and prays for a copy of contempt petition. The Learned Counsel for the petitioner shall provide 2 copies of the contempt petition to the Learned Counsel appearing for respondent number 6 and 7 within 2 days. It is because of this order I wanted you to call him.
Yes, my lord. That is why, my lord.
But if you don't give him copies, we adjourn it. Let it register after 4 weeks. How much time you need to give copies?
Mara, in fact, in this matter, some of other lawyer was appearing, and I just got the instruction.
You file an application to strike out this order. You file an interlocutory application to strike out the order date, to recall the order date.
I can serve extra copy, my lord.
No, how many days?
Today,
No,
I can serve today, my lord.
You have touched my heart. Because I come from the civil court, you have touched my heart. You file a suit seeking recovery of that 2 copies which you gave to the other counsel. Civil suit for recovery of that 2 copies. Agreed, do it. Can I record it in the order that you are at liberty to file suit for recovery of 2 copies of which you gave to other counsel?
My lord, I can serve today, my lord.
You will serve today?
Yes, my lord.
Okay.
Can serve today.
Okay.
Otherwise, Madan was appearing, and I just got, he informed me that other lawyer was appearing, and then he has already served their copy. That's what's saying. Madan,
I don't know, I go
as
by.
as per the order, if I see, Mala, I agree to that order, Mala.
Okay.
Then I will serve extra copy.
Okay. Mr. S. Mohl, I'm counsel for the petitioner. And directs to serve 2 copies of the contempt petition to Mr. D. Kamdut, Learned Counsel. Appearing for respondent of 5, 6, and 7 in course of the day-to-day. Next para. The Mr. Kamdut, D. Kamdut, Learned Counsel, appearing for respondent numbers 6 and 7, shall positively file his Vakratama. Yes. At least 2 days prior to the next date of listing, failing which the court would be compelled to take coercive steps for personal appearance of the respondent numbers 6 and 7, as their appearance before this court has not been dispensed with. Full stop. You have for?
And for respondent number 5.
Respondent number 5. Mr. A. Learned Counsel. Respondent number 5 is present. Yes, what do you have to say for 5?
Five, they have filed affidavit, man.
I filed.
You filed an affidavit. What do you say? When did you file it?
It was filed on 4th April 2023.
4th April
2023.
23. Okay.
Not 4th, my lord. It is as per this in the affidavit is 31st of March 2023. 31st of March.
Mr. Mo, where is the order of payment of solation? You have filed this contempt?
No, my lord, my case was that compensation and solation including both.
So where is the order of solation?
My lord, just go to that. Page 22, my lord. Page 22, my lord, it start from para 5, I read. Instant writ petition.
Where is this order of WPC 280?
Yes.
Where is that?
280, yes. My lord, 280, my lord, you also must see page 21.
Which page is that?
Judgment is, my lord, is in page, my lord, it start from page, it starts from, my lord, page, it's
23.
Start from 23. Okay. And operative is, my lord, is in page 59.
59.
59, my lord. And para 5. Relevant is in para 60. Para 55, sub clause 4. Married, my lord. The
No,
petitioners.
don't read.
Yes, my lord.
Read it.
Yes, my lord.
Okay. Who is respondent number 5? What is his designation?
General Manager, my lord.
Manager NHDCL.
Yes, my lord.
And has this this is a contempt filing 280?
Not 280, my lord.
Non-compliance of which order?
Yes, my lord. The contempt is, my lord, is from 245, my lord.
Which page?
My lord, page starts from 14.
Page 14.
Yes, my lord.
245.
14. This order was passed selling the judgment and order of WPC.
Please tell us why the name of this respondent number 5 should not be struck out.
Respondent number 5.
5.
5, my lord, they are the executive agency, my lord.
You come to page 18. That's why we are searching for. That's why I had some issues in this matter. Come to page 18.
18, my lord.
That is your cost title, page 17, 18.
Yes, my lord.
Right. 18, who is the party? NHIDCL, represented by its general manager P.
Yes, my lord.
Now you have read respondent number 5, who is general manager administration. How is he in contempt? Now tell us whether you gave him notice to perform to abide by the order of the court.
Yes, my lord. General Manager P, my lord.
Yes.
And then our respondent, my lord, says General Manager
P.
Administration.
He's general manager administration. Please tell us why he should be in contempt.
Yes, my lord.
And then you'll have to show us that you gave him notice to comply with the direction of the court. Order passed in 245 was communicated to him to comply with it.
Pipe is in the office shows Itanagar, and then here it is rowing.
So we are putting
main office is in Itanagar, NHA Departmental office, my lord. I think that's how
No,
it is.
you see, I am not supposed to know everything. I have seen the cost title and then I am asking you.
Yes, my lord. Yes, my lord. Yes, in court title.
How he is in contempt? Where is the office? It's not my. I cannot know that.
It's P. P is written, but here this general manager.
Mr. Mo, I have a very weak memory. Every day, learned counsel come before me. Every day I have to ask them their names. I'm so forgetful. So unnecessary things, if you tell me, it is of no use, because where is the office? I am not supposed to know that.
Yes, my lord.
But I am supposed to adjudicate whether a right party is in contempt or not.
5, but then 5, they have filed affidavit, my lord.
Let them file an affidavit, but the query of the court is whether he is in contempt. If somebody files and says that, well, you see the crisis in Uganda, if I give an affidavit or somebody else gives an affidavit that I am responsible,
Yes,
What would happen? So his affidavit doesn't carry any meaning unless he's in contempt.
yes, my lord.
In order to show that he's in contempt, you'll have to tell us that he was a party in the writ petition, or he is a necessary
Necessary.
administrative officer upon whom notice was served to comply with the direction of the court, and therefore he is in contempt. There are two
Yes.
possibilities. So in these two categories, where does he fit in?
Well, only address is different, my lord.
P and administration are different.
Yes.
P, I don't know what does P mean.
Yes, my lord.
What is P? I don't know.
Yes, my lord.
Administration, I understand.
Yes, my lord.
So I'm putting you to notice to tell us why their name should not be, why his name should not be struck off. The next paragraph, you write. It is observed that the respondent number 5 in WPC 245 of 2021 is National Highways and Infrastructure Development Corporation Limited, represented by the General Manager P. First off, the respondent number 5 arrayed in this contempt petition is Sri Pranjal Pratim Borgohain, who is General Manager within bracket admin ADMIN and LA bracket closed. So therefore, the learned counsel for the petitioner shall address the court on the next date as to how the respondent number 5 is in contempt. First off, next paragraph. List the matter on. How much time, Mr. Kandu, to file affidavit? And what are the month?
The judgment of the order of Honorable Court has been complied with. They are not saying that compensation was not paid. They are only saying that by this contempt petition. They are not saying that the state is better. They are not paying the compensation. That is
I did not get it. Please. No, but tell us what do you mean by what you said? I did not follow you. Please repeat again.
Deputy Commissioner and contempt number 4.
Yes. Yes.
The order was connected with petition has been complied with.
No, Mr. Mao is asking two things. He is asking for the compensation as well as the solatium. So you'll have to spell out correctly that
yes.
the amount includes solatium. Compliance with the order, we don't understand. Wait.
Because they are also correct in the contempt. Not only because also for a petitioner, you may supply a copy of the contempt petition to me.
You see, I'll tell you, there's a gap what you read and what you understand. Here in paragraph 6 of the affidavit, they say that there was a consultation with the stakeholders in the proceeding for an amount of rupees 352,34,769. Who are the stakeholders? We don't know. Then you say that thereafter letter dated 31/1/2023 was received from the Director Land Management seeking for clarification on the increase of compensation amount. Correct? And then clarification is received by the Director's Land Management. Paragraph 8, you say, on 23/2023, letter was received from the Director so-and-so conveying the approval of the government for compensation of rupees 352,34,769, exactly the same amount which is there in paragraph 6. So where is the solatium? A contempt is writ large on the face of this affidavit. You don't have to go anywhere else.
Even petitioner also, there is around 20, above the
That's why-
20 petitioners.
No, we have proper instructions by way of an affidavit. So you see that amount is same, therefore contempt is made out. Oh, that was dismissed. Don't tell us everything. Not in this writ petition. No, I am not concerned with everything. In Supreme Court, there may be 2 lakh cases pending.
Yes.
Why should I bother myself for that? I should bother myself with the. No. Your SLP in this writ petition was dismissed. Whoever filed is your, I don't say. Somebody filed an SLP in this 3-45 that is dismissed.
They file a review also, they also dismissed, my lord.
Okay, this is an additional information.
Yes, my lord.
So you see, that much I have read. Otherwise, they would not have told you this much. Correct. So the contempt is actually made out. But then I found this 5, I did not. Suddenly it caught my attention. I don't know why.
Yes, my lord.
For others, I did not examine, but 5 somehow caught my attention. Correct. So you have to tell us some more, something better than what is there in the affidavit. Now, how much time? 2 weeks? 4 weeks? Okay. List after 4 weeks on a date to be fixed by the office. But I've made it clear. 6 and 7, their personal appearance is not dispensed with. Therefore, if you don't file an your wakalatnama, then we are calling them.
Right.
Yes, 9 to 15, you made a prayer for adjournment. Correct. Let me see this.
Your Lordship, my brother is seeking time for.
No, correct. I remember he's made prayer for adjournment. You said they'd taken 5 adjournments. Correct.
4
4
including
adjournments.
today it's 5 people. Your Lordship, allow them to file.
Yes, yes, yes. You see, you had opposed it, right?
Your Lordship?
You had opposed the prayer for adjournment.
No, I'm not proposing. But however, my leading counsel, my senior, is out of
No,
station.
no, you, in the morning, you opposed the prayer.
No,
Correct.
I'm not opposing. Actually, they are so 4 times. Today is included.
Correct. You
So
opposed the prayer
let
for
them-
adjournment, right?
let them allow.
Please answer to my query.
Yeah, Your Lordship.
The prayer for adjournment was opposed by you by saying that 4 adjournments are taken, right?
I'm not opposing, but let them allow.
No. Don't change words.
Your Lordship.
You said that there were 4 adjournments taken, right?
Yes.
You see the records. In this, as per this order sheet, that's why I adjourned, I said that the matter would be considered after I take up the matter. You see, I've checked the record. 29/1/2024 notice was issued. 24/4/2024, On the prayer on behalf of Mr. T. Tagum, the matter was adjourned and the Honorable Judge has recorded that the prayer is not opposed. Yes. Correct. Next after 3 weeks. Now, the matter was thereafter listed on 26/2024, and the court has recorded on the prayer of the learned counsels. Counsels mean
Both the
it's
parties.
using plural. List this matter after 4 weeks. Then it has been listed today. So therefore, one adjournment by him, second adjournment is by the counsel for the parties. Where is for adjournment? Please find out.
Lordship, I was inserted that.
No. Don't have those impressions. You are young lawyers.
Lordship.
You have to shine higher in life. Don't make such statements which compel the court to read the order. You see, I wasted 5 minutes of my time reading this. I'm spending 5 minutes more time to tell you what you have, what mistake you have committed, and then I'll adjourn the matter.
Lordship.
Correct. How does it help you to grow in and shine in life? Don't do it. You just had to consult the record and tell us. You don't make incorrect statement before the court.
Lordship, highly apologize.
Don't do it. Because and the entire day of both of you are wasted in the process. My 10 minutes and your entire day. Who benefited? Okay. You're for? Why you want an adjournment on his behalf? No. I'm not on that. Personal reasons are not being asked. In this case, notice was issued. You have filed a response. Then why we should not impose a cost?
In this case, similar matter is pending before.
I am not concerned with similar matters. In this case, we have issued a notice. You tell us about this case.
Illegal appointment.
No. Don't tell us those things. You see, those stories we have read. I don't come here without reading. Your case is that the initial appointment was illegal. What is preventing you to file an affidavit to that effect? Why you make oral stories? Don't tell us stories. You see, we don't know about illegal appointments unless you file an affidavit. Why don't you file an affidavit and tell us? You want us to hear oral stories while deciding a writ petition? Shorted means we give you 2 weeks time. Before vacation, you file an affidavit. Otherwise, we don't allow that.
Yes.
Don't tell us about other cases and all. In this case, somebody has come, you respond to this, or you file an affidavit saying that your affidavit in earlier case will be followed here. Something must be said on affidavit. Even if you want to follow an affidavit of filed in some other case, you file an affidavit here saying that you are accepting that in this connection with this writ petition. All sides are represented. One last opportunity is granted to the respondents to file affidavit in opposition in the matter, failing which the court shall invoke the doctrine of non-traverse and proceed to hear the matter on the basis of materials available on the record. Expect this after 2 weeks on a date to be fixed by the office. Pass separate orders in all these cases. Separate orders, huh? All these cases. Okay.
Deeply able.
Yes, Mr. Patil.
Well, this is a matter of acquisition of land. Well,
Yes.
the Border Road Organization, they have established one petrol pump retail outlet. Well, after the Chinese aggression, well, since then the matter is pending. And on the last occasion, Malad, it was measured. Your Lordship may kindly come to page 11 of my writ petition from the annexer itself. my
File
lord.
an affidavit.
Well, government has filed. Let me just make a submission. There is a
Yeah,
there is a
your case is that the recommended payment is not being made. That is the only case you have.
government has made a calculation, but they have made a slight mistake there. So this matter may have to be revert back to. That's why I'm coming. You
Where is
may
that?
come to
Where is
page 11, 12. Page 11 is the forwarding letter. 12 is the spot verification. Here even the border organization they were
page number?
11 is forwarding letter, annexer 1, annexer 2. I'll start from annexer 12. 12 is the sketch map of the area. This is a small area, 1.6 is acre area. Lordship, make page 13, my lord. Page 13, this is the compensation of the land, my lord. My lord, let me be very, very frank. I do not have any objection to the rate which the government has calculated. Page 13 is the land compensation. Now page 14, my lord. Page 14 is the rental.
And that's what I said.
Rental, my lord, down below, my lord.
No. You see, your projection in this repetition is that the rent up to 2019 was calculated. Now the current rate.
No, my lord, let me just, my lord, here, page 14, down below, interest, just after the table, my lord, interest at the rate of 9% per annum as per section 80 of the right to fair compensation such and such, my lord.
Yes.
Now, my response submission is this: section 80 does not apply on the rent. Section 80 apply on the land. It should be against this page 13 calculation. So, my lord, let them, my lord, just by pointing it out, let them determine again.
Okay. Yes.
Lordship, with that regard, I will take instruction, Lordship. This
No, you see,
calculation
in this case, he is being fair. He is right in making a statement that the interest on rent is not payable.
Yes.
So you just have to add the rent of till 2023 and deduct interest which you have already loaded on the amount. That would be fair compensation. He's asking for reduction.
This cannot sustain. This is a wrong calculation.
He's asking for
this needs to be
reduction.
revisited. Amount may increase or may decrease. That is different thing.
It's a fair submission. He's right also. Because that's why I was telling him that you wanted the rent to be added for the period, but he says no, he wants the reduction of interest. So that has to be done. Either you do it. You take instructions and do it.
But I think instruction is also not required. This is the provisions of law only. Because under section 80 of the LADA Act, it is applicable only for the against the compensation only. So this has been included in the rental. So this is typographical error.
Correct, you're right.
Yes.
You are absolutely right. But dispose of the matter.
With this regard, I will take instruction, Lordship. Because, Lordship, union is also there, Lordship. They will only give
What will,
no, because
calculation part, I will take instruction because, Lordship.
no, you see, you do it. We are not saying no to you. But what is the submission of Mr. Patil is absolutely fair. Correct. There won't be interest on rent. Rent is a component which is a separate component.
Yes.
And therefore, on rent, his simple submission, as I have understood, is that he wants rent to be excluded on interest component, and you add up the interest up to the 2013 somewhere he's asking. 20.
Otherwise, then let us fix it on next Tuesday or Wednesday.
You are asking for rent till which period?
They have calculated from since 1962.
No. Rent was calculated up to which year?
2019.
2019. So he wants till 23 now.
And that is the extent of the government only. They are saying that this has to be revisited.
Next week?
We have filed affidavit. Yes, Lordship, I will take instruction.
Okay. Next paragraph.
Next
Is it
week,
me,
Lordship.
right?
Third stream.
Mr. Tony Pertin, from Learned Counsel for the petitioner, has fairly submitted that that in land acquisition compensation under the
Lara, so in
the
short, Lara.
land acquisition, give the full name, huh? The Land Acquisition Act, comma.
Specifically, section
interest
80.
is not added to the rent component, and interest is otherwise calculated on the property which is acquired under the provisions of section 80 of the said act. It is submitted that the authorities in making the calculation has made an error to add the component of interest also on rent. Accordingly, he submits that the said correction is required to be made in the computation of compensation. Next paragraph. It is further submitted by the Learned Counsel for the petitioner that the authorities have calculated rent component till the year 2019, and therefore the petitioner is also entitled for area rent up to 2023. Full stop. The said prayer is also found to be in accordance with law. Next paragraph. Therefore, on a query of the court as to whether the matter can be remanded back to the authorities for a recalculation, comma, Ms. G. Learned government advocate prays for some time to offer instructions. Full stop. Next paragraph. Mr. M. Kato, Learned DSGI, as well as Mr. D. Kamrup, Learned standing also for the Land Management Department are present. Next paragraph, list on date.
26.
Wednesday, madam, the next.
26. All the officer Lordship.
When? Give a date.
26.
26.
26.
26.
But there is no point taking so long.
29. 26, 9, 29. Because it's right, unless unnecessary to be delayed for some days. Calculation has to be made. It's otherwise fair.
Obliged.
Number 17. Yes. No, that is refused. It's a 2021 matter. You have taken 3 years.
Yes.
Affidavit.
Yes,
No.
Lordship.
Now we'll give you on a cost 3 years. 20,000 into 3 is 60,000. On payment of cost, now we'll permit. Yes, Lordship. So we are imposing a cost of 60,000 to file affidavit.
Yes, Lordship.
Correct?
Yes, Lordship.
Agreed.
I'm gonna have to ask my senior. I'm standing on behalf of standing counsel Tabatagum.
Okay. Outside the represented. Mr.
A Podo.
A.
Podo.
How do I spell it? P.O.
Podo.
Learned Counsel appearing on behalf of Mr. T. Jamo, standing counsel for the
T Tagum, my lord. T Tagum.
T. Tagum,
Tabatagum.
standing counsel for the Education Department.
Yes.
Prays for more time to file affidavit in opposition. Next part. It is noticed that we take note of the fact that notice And this writ petition was issued by order dated 8/12/2021. And a lot of adjournments have been taken by the Education Department to file affidavit in opposition. Full stop. Even today, the affidavit in opposition has not been filed. Full stop. According for the delay caused by the Education Department in filing of affidavit in opposition, the court is inclined to impose cost for causing delay upon the School Education Department, which is computed at rupees 10,000. Full stop. The cost of adjournment shall be paid to the petitioner Srimati Yaram Jamo within a period of 1 month from the date of the order. So the said cost is imposed taking into consideration that at the relevant time, the petitioner was serving as a contingency peon and her service was terminated by order dated 28/7/2010. The said cost is made a condition precedent for acceptance of the affidavit in opposition. Stop. In other words, it is made clear that if the cost is not paid to the petitioner, the affidavit in opposition by the School Education Department, represented by Education Department, represented by respondents 2, 3, 4, and 5 shall not be accepted. Next paragraph. The one last opportunity is granted to the petitioners, to the respondents, file an affidavit in opposition within 4 weeks from today would be within 21/10/2024. Stop. The respondents are put to notice that in the event affidavit in opposition is not filed within the time permitted, the court would be inclined to invoke the doctrine of non-traverse, and court shall presume that the state has no opposition to this writ petition and appropriate orders would be passed on the basis of materials available on record. Next para. The learned counsel appearing for the Education Department shall transmit a downloaded copy of this order to the respondent numbers 2, 3, 4, and 5 for compliance of the order of payment of cost. Next para. List on 21. We make it 23/10/2024.
Deeply obliged.
May I plead your lordship? In this matter, my lord, respondent number 5 has filed affidavit, and 2, 3, and 5 to 27 is a private respondent. 28 to 30 is Union of India, my lord. They have not yet filed affidavit. In 2, 3 occasions, they have taken time to file affidavit, my lord. Matter relates to land land compensation occupied by the armies, my lord.
So what is the matter about
This matter relates to
compensation?
land acquisition, my lord.
Okay. Where is this order dated 19/5/2022?
19/5.
Where is the order dated 19/5/22?
19/5/22, okay, my lord. 19/5/22, 19/22. My lord, it's in page 133.
133.
Yes, my lord. One chapter three, my lord.
It is in 126, my lord. What is wrong in the order?
My lord?
What is wrong in the
Yes,
order?
my lord. My lord, there is two notification, my lord. One is earlier notification was in 2010, my lord. It's in page, my lord, earlier notification is page 48, my lord. And then fresh notification in 2014, but then they have not followed the land acquisition process as per the notification 2014, which is in page 67 and 70. And then without following the notification, they included only the few landowners, and the real landowners, many of the landowners, they were left out because there was no any notification that section 4, 5, 6, nothing, my lord. They just preliminary they have meant a word as per the 2010 notification, but
You see, those things are matter of past. There was a writ petition earlier,
yes, my lord.
and in all probability, this court took notice of what you have said.
Direction was that it has to be fresh assessed, my lord.
The fresh adjudication is made, and they say that except for 26 people, no others are included. So where is wrong?
Now, impugn order, it says that preliminary was held in 2010, my lord, whereas the fresh notification in 2014, my lord. So if it is notification in 2014, then the whole process should have been started with the notification in 2014, my lord. When 2010 notification is left out, it has not been affected.
Where is the order of this court?
Yes, my lord. Order, my lord.
Is that order at page 93?
Yes, my lord.
Is that High Court order is at page 93?
93, my lord. Let me check 93. Yes, 93 was the petitioners they have filed saying that the grievances were before.
Who are these petitioners? You are the petitioners?
Yes, my lord.
Correct. Now, this land acquisition notification of 2014.
Yes, my lord.
Was it brought to the notice of the High Court when this judgment was passed on 24 to 2021?
2000.
this judgment was passed on 24/2/2021. Did you bring
Yes,
that?
yes, my lord.
Did you bring that
Yes,
notification?
we have, what we have said is that, my lord, notification 2014, and within 30 days, we also filed a representation to the Deputy Commissioner, my lord.
You're not getting it. You see, in this order, come to page 101.
Yes, my lord.
In page 101,
Yes, my lord.
paragraph 1, you have referred to accordingly by notification dated 26/2/2014. Possession of the notified area in the said notification dated so and so was issued. Correct?
Yes, my lord.
So this court took cognizance of that 2014 notification
Yes, my lord.
and this order was passed.
Yes, my lord.
And in compliance of this order, the Deputy Commissioner makes a adjudication. What is wrong in that?
My lord, we were asked to file a representation before a Deputy Commissioner, my lord.
But then writ petition would not lie. It's an adjudication under the Land Acquisition Act. If you are aggrieved by that, you file an appeal.
My lord,
An appeal will not lie because inclusion of names is something which is to do with section 11, 12. I forgot the sections.
my lord, what we are
Adjudication of claims.
my lord, what we are challenging is that acquisition process is void ab initio, my lord.
You can't do it.
That is what we are challenging, my lord.
You have to read CPC, Order 2, Rule 2. Read with explanation 4 to section 11 CPC. A prayer omitted to be in the first case cannot be permitted to be raised in the second case. You are stopped in doing it. It is called what you call constructive res judicata. Principle of Order 2, Rule 2 is that you cannot file successive writ petitions claiming one relief after the other. So you have to dismiss your writ petition.
My lord, the direction was only to dispose our representation, my lord.
That was done. Now, unless you see your right title interest, for that now a suit will not lie to be included, and therefore your claim ought to have been a claim under section, I forgot those sections, why I don't know. Section 11 or 12, is there adjudication with regard to the entitlement, LA Act. So that is a thing of the past.
In fact, in our writ petition also, our this one prayer was that the whole
Oh, rightly, I did not remember this section 11, 12. You know why?
Yes.
I now recollect. Initially, a land acquisition notification was issued under the Land Acquisition Act.
Yes, madam.
And midway, the state government revoked that and issued a compensation, what you call land acquisition notification under the Balipara Tilap Act.
Even section 14 also, my lord, section 14, 133, my lord, notification 2014, my lord.
So therefore, you see, under when it is the acquisition under Balipara Tilap Act, then there is no provision under the said act.
No, even section new notification also notified under my lord,
I don't
Balipara Tirap.
whatever. You
Same
see,
notification, same act, same
okay,
regulation.
whatever be,
Yes.
maybe under the same act. But you see, the problem with this act is that unlike Land Acquisition Act,
Yes, madam.
claims and objections, whether there is a provision or that, I don't know.
The claims and objection, my lord, it has to be within 30 days. We have filed a claims and objection, my lord. We have filed a claims and objection, but then our application was not entertained. Now, instead of entertaining our application, the deputy commissioner passed this impugn order saying that the notification has been, the award has been passed as per the 2010, my lord. That is the impugn order, my lord.
So you can't do anything. Now you can only think of any other remedy which you can avail under CPC. If there's already an award, that cannot be disturbed with a fresh adjudication of new claims. Then also you fail.
My lord, give me some more time, my lord.
No. You see, it's not a question of time. You can't improve anywhere.
Yes, ma'am.
Because we are in a writ petition. In a writ petition, I can't declare your right, title, and interest vis-a-vis other persons. We are prohibited from doing so under writ jurisdiction. So you essentially have to go and file a suit. Suit under land acquisition proceedings is not maintainable.
Yes, my lord.
All claims and objection must be made within the ambit of a Land Acquisition Act. In the Land Acquisition Act 1894, it is section 12 or 13. In Balipara Act, I'm not acquainted, I'm not sure where your objections can be filed. You said within 30 days. But that objection within 30 days, although you say that you have been filed, but the award is of 2010.
We have filed, my lord. We have filed, but then
the award of 2010 can't be undone even by a writ court. Assuming we have all the power, we still can't undo that because this amounts to, you see, under the Land Acquisition Act.
No, my lord, there is two.
Past. No, let me complete. Otherwise, you won't understand where I'm going. I'm not as simple as straight line. I'm simple and straight as a jalebi. Many twists and turns. Then you have that very sweet thing. Correct. Now you see, so far as the land acquisition under the 1894 Act is concerned, under section 54, it's a decree. Now, how does this Balipara Act treat a land acquisition compensation? I don't know. But nevertheless, to include your name, essentially that award has to be set aside. Now, can we set aside an award in a writ petition?
$2010, my lord.
Whatever the date is the award. The question is the award, can it be set aside?
No, 2010, my lord.
You please answer the query I am making because there's after that there will be another question. Don't distract me. You see, an award, can it be challenged in a writ petition? An award of 2010. That's number one. Number two, the award adjudicates right, title, and interest of parties, entitling them to a compensation. Now, can that be undone in a collateral proceedings? In this proceeding, you are not challenged that award. You are merely saying that my name should be included. Now, can a decree be modified in a collateral proceedings? Two questions now.
My lord, we have challenged, my lord, that award also, my lord. Saying that we have challenged also, my lord.
That act. Give me a copy of that act.
My lord, say
Balipara Tirap Act. Volume 1. Give that.
But the
What
deputy
is the procedure of challenging that award?
Deputy Commissioner says that he's not talking about 2014 notification. He's talking about 2010 notifications, my lord. When 2010 notification is nowhere in force, my lord. Because the fresh notification is issued in 2014. So it has to be as per 2014.
Just a moment. Yes, there is a provision of appeal under section 17. You avail that. If you have challenged the award in a petition.
But even this This has been, my lord, been modified, saying that even if notification is issued under section 10 of Zoom regulation, compensation can be assessed under the Lara Act, my lord.
Oh, that is different.
Yes, my
Has
lord.
nothing to do with
Because
this.
this, my lord, the same case was appealed before the governor.
No, for that, you don't have a locus standi right now. You're not even a part of the award. So therefore, whether the award should be in Act, under Act A or Act B, it's not open to you to address that. Your name is not inside, not in the award. So what would be the award is a question which you can't answer, or you can't put in the first place. Now, if you want to challenge the award, the only way is not in a writ petition, but to approach the appellate authority under section 17. We can't circumvent and have this writ jurisdiction exercise for declaring right title interest. Because we'll have to say that your interest exists in that land, on that land,
Yes, my lord.
entitling you to a right to be included in the list of beneficiaries and then to share compensation.
But then this impugn order which Deputy Commissioner has passed, if he has rejected our application on the basis of 2014 notification, then it would have been different situation. But then he clearly mentioned that we are not entertaining your application because award is made in 2000 and the hearing is being done in 2010, my lord. Whereas 2010, the notification is nowhere enforced, but fresh notification in 2014. But if Deputy Commissioner says that it is in 2014, we are not entertaining that, that would have been different situation, my lord. The case is of the Deputy Commissioner, the impugn order says that hearing has been done in 2010 notification, so we will not entertain your application. This is the case, my lord. That's what, my lord, impugn order it is mentioned, my lord. That's just, I will just take you, my lord. My lord, it's in page, page 138. 138, may I just read the second,
Yes.
last paragraph, my lord. Sufficient time was given to the file claims and objection. Preliminary notification dated such and such 5/6/2010 of the land management, Itanagar, such and such 3/8/2010 of this office. And second, third, it says hearing was conducted as per the provisions of section 5A of LA 1984, 1894 on dated 7/3/2011 at such and such area, that is such and such place on dated. For the matter ownership already been disposed of by district admin 2011. So this says that the claim and objection has been done into.
Where is your application before the Deputy Commissioner?
Yes, my lord.
Where is your application before the Deputy
Yes,
Commissioner?
my application is, my lord. My application is, my lord. My application, my lord, 2022. Yes, my lord. Page 71, my lord. 71 to 74. my lord.
Page 71.
Yes, my lord, 71. My lord. Dated 12/3/2014. Same was also received on 12/3, my lord. May I read the prayer? For payment of compensation for the land occupied by the army at such and such, Dening is our ancestral land of India, Yun, Tamai, Kathak, Tayang clans. Reference notification, my lord. Dated such and such 26 February 2014. That's it is submitted that we are on.
No. You're just beating around the bush. You see, High Court passes an order on which date?
My lord, High Court passed an order, my lord.
Sometime 21, 22, 23. Where is that High Court order?
My lord, order is, my lord, page 93, my lord.
Page
93.
93, yes. What is the date of the order?
Date of the order is 93.
24 to 21. And you say that after this order, you gave a representation in 2014. Very good.
24. Because this was filed after when our application
We
was not
don't know. You
considered.
see, the High Court passes an order. I have said that where is your representation? Then you refer to a 2014 representation.
Yes, my lord. The fresh representation we have filed, my lord.
I am not interested in first. Please understand the context in which I am asking. I am asking you on the context, you say that in the High Court we made that representation. So we read the High Court order. Then you said that we made a representation.
The representation was to the notification, my lord. Notification,
No,
2014, my lord.
You see, we don't bring those
That-
things. If you don't, after the High Court order, if you don't tell the Deputy Commissioner what the fact is by submitting a representation, you want another order from the High Court? It's just not permissible. Because we don't have the earlier writ petition, we don't know what what you stated. In the High Court order, the reference to 2014 notification is made. Now you want us to believe that the 2014 notification, no notification was issued, in fact, requiring for the objection and all. And then
Yes.
This is taken.
When the representation was not disposed of, then only when we come to the High Court.
Where is that notification of 2014?
Yes, my lord.
Where is that?
Yes, my lord. It's in, my lord, it's in page 67, my lord.
57.
When our representation was not considered, and then only we came to the High Court, my lord. 67. My lord.
67.
Yes, my lord. Annexure 4.
You filed your affidavit, any one of you? Where is, what does it say? About the land acquisition notification, which is the notification?
Yes, that's it. The commissioner said after the under course direction also. In the I feel the
Just a moment. Where is that notification, 2014, where is that?
Notification is my life in page 67, 70.
67,
67, 70.
67.
Yes, ma'am. And our,
Just a moment. So, let it come with the other writ petition, otherwise we'll be passing inconsistent orders. All sides are represented. Apart from the deputy commissioner, Teju, district, deputy commissioner Lohit district, no other respondents have filed their affidavit in opposition. Next paragraph. In order to examine as to whether the stand of the petitioner is consistent with the previous writ petition, the court is inclined to examine the records of WPC 50 of 2021, which was disposed of by order dated 24 to 2021. Next, but accordingly, the registry shall tag this as record with this writ petition. Next, for list on listing it next Wednesday. Next Wednesday, list on 25/9/2024. 25/9/2024.
Apply.
Even if the record is not found for some reason, you be prepared with the earlier writ petition record.
Earlier
Like to go
petition.
through it. Like to go through it.
But the first round of petition will also be required, madam. 153 of 2013, madam. 53 of 2013.
No, 2013 will have no reason to be called for.
Direction was in fact given to the district
No,
administration to ascertain the rate, madam.
No. You see, that is not necessary for the simple reason that the case now projected by Mr. Mo is that 2010 notification
Right.
was superseded by 2014 notification. He says that under the act, he gets 45 days time to file an objection, which he did. And that objection is not considered. And he says that the award was not passed in 2014 notification, but the award was passed on the basis of 2010 notification. So therefore, if the 2014 notification is the one in which the land was acquired, a writ petition of 2013 is not necessary.
Right.
If you have a copy, please produce it, we'll see, but by judicial order, we are not calling that.
Madam.
I have filed an
She is not good. Ms. Danjan is not good.
Sorry, sir.
You're
Sorry.
not good. You woke him up unnecessarily. It's not fair.
We have filed an application for vacating the interim order, which
You see, he wants to vacate and you are waking him up. Ah. For vacating the interim order, why we only grant, very few cases we grant interim order, why should we vacate?
Idiot. Well, we are direct recruits.
You are?
We are direct recruits.
Direct recruits.
My lord.
Okay.
They are the promotees. They were initially officiating in the post, but then they were regularized in 2019. I was directly appointed in 2009. Now they have filed first writ petition in 2022, challenging the, my lord, oh, item 22, my lord, I think he did My lord, in the earlier case, they have prayed for giving them retrospective promotion. And
Just a moment. But Mr. Mazumdar,
my lord,
as you said that the earlier petition
my lord,
was to give retrospective promotion.
my lord.
Now we don't know where after this whether this writ petition would be allowed or not. 2014 writ petition.
Yes,
But assuming that this is allowed
my lord,
and we vacate the stay,
my lord.
then you become entitled to a promotion to the next higher post in the DPC.
Further promotion.
And therefore it can't be, the situation cannot be altered.
No, my lord.
So we can merely say that we can hear the writ petition out of turn, but to vacate the order would be.
My lord, there is a reason why we have filed this application. My submission, I show, my lord, I have prepared a list of it. So even if their writ petition, the first writ petition allowed, our position cannot be altered because in the first writ petition, they have challenged their own DPC. They are saying that this DPC has given them regulation from 2019. So they have challenged only that. But all vacancies existing prior to that were filled up by their seniors by a recommendation of DPC of 2012. That has not been challenged in the first writ petition. So if that is not challenged,
Then the corollary would be.
my lord,
that since you are a direct recruit,
my lord,
your position will always be above them.
yes, that's what I'm saying, my lord. They can get up to a certain extent, but not beyond, not prior to 2012. And we were directly recruited in 2009. So there are many respondents, but so far as these present applicants are concerned, my lord, they cannot in any case come above us. For two reasons, my lord. One, 2012, there was a recommendation of DPC. That DPC recommendations recommended few seniors of them, and all the vacancies were exhausted prior to that. They have not changed because they are senior. Now, after that, 2009, we were directly recruited. They were regularized in 2019. Now, 2019 selection, DPC recommendation, they have changed in the first writ petition, saying that they should be regularized from the date of their officiating promotion in 2005. This is the only ground they have taken. And in the present writ petition, they have challenged the consequential seniority list prepared
of all these persons. So if the first petition, there is no interim order. In the first petition, if there is no interim order, possibly my humble submission, in the second petition, they are not entitled to any interim order. Because now by doing that, they are halting the further DPC proceeding. And their only ground on which they are asking for regulation with a retrospective effect from the date they were officiating is that in the direct recruits case, when principles have been laid down. In the second case, if they have been continued, even if it is officiating, if this uninterruptedly it is continued, then they should get the promotion from the day one. That is the on that. But that finding of direct recruit, direct recruit, is based on a judgment of 1977 Supreme Court 77 3 SCC 399. There, I have read the judgment. There, vacancies were there, but here, since vacancies are not there, there is no question of they will get there.
Where is the proceedings of the DPC
Of my lord,
which they are challenging?
Challenging, my lord, it is there. 2019 or 2000. No, from the petition to. No, it was page 52 of the present petition. Page 52.
52 of the writ petition.
Of the WPC, yes, of the WPC 295. 295, man.
295. Page number?
Page 52. 52, man.
52.
नाम को पता है দুজন মানে 4, 5 and 7 page 250 page 52 The meeting of Group A Departmental Promotion Committee notified by number so dated 31/10/2019 was held on so at so in the office chamber of Chief Secretary to consider promotion regulation of junior engineers in the rank of assistant engineer in the Department of Hydropower Development. The following were present in the meeting. The DPC examined the vacancy positions. Normally, vacancy positions were examined. Immovable property return, APAR grading, vigilance, clearance, integrity certificates of the officers in terms of the recruitment rules of assistant engineer civil 2008, recommended promotion, regularization of following
I wanted to see this, the day on which this post, which was being considered in this DPC,
My lord.
fell vacant.
My lord.
Fell vacant.
My lord.
What is the date on which those vacancies were notified?
Against which they were appointed, man. These are all after 2012.
It's 2012.
I have this in this list of dates, I have indicated everything. My lord, I am coming to this is one by one. There are 3 petitions in the petition. First, the petitioner was allowed to hold charge of their working as in the substantive capacity as JE, hold charge of AE till posting of regular AEs. Now, next date, petitioners along with one so in partial modification of earlier orders, dated so were allowed to further continue now on functional basis. In 2009, my lord, we were directly created by the Public Service Commission. And they were working against the posts which were meant to be filled up by direct recruit. This is indicated, my lord, lordship, in the second page, my lord, page number in heightened.
I've seen that. You are referring to page 25 of the writ petition.
Page 25.
Yes, ma'am. Yes, ma'am. Against direct recruit profile.
Has the state filed affidavit in opposition in matter, Mr. Ram?
My lord, in
State
IA or my
affidavit?
lord,
No, in the main petition.
Main writ petition, my lord. No, my lord. Because notice was,
Because you'll have to tell us the stand of the state.
My lord.
Whether the petitioners are working on the in a vacant post, which Mr. Mazumdar says was for direct recruit.
if your lordship peruse the subcommittee report, my lord, that is annexed in the writ petition 295. If your lordship see, my lord, page 75, my lord,
Page number
page 75.
75, yes.
This is the subcommittee report, my lord. Your lordship go to 75.
75, yes.
Yes, my lord. So the total post of assistant engineer is 48. And each line, the promotion will get 24 and the direct recruitment will get 24 posts. And as per the above statement, department has filled up 24 vacant posts of assistant engineer being officiating vacancies. So if this is the fact, my lord, then where's the question of my lord exceeding the promotion quota? This is the subcommittee report, my lord. So total strength of the department is 48, my lord. So 24 is 48.
As the assistant department had filled up 24 vacant posts of assistant engineer,
My lord.
being the officiating vacancies.
Yes, my lord.
Official vacancies in which cadre?
Assistant engineer.
No. Direct recruit or
No. From my lord, assistant, from junior engineer to assistant engineer, my lord. And
you see, I'm trying
another
to,
is my lord, direct recruitment, no issue.
I'm just trying to analyze the submission of Mr. Mazumdar. You see, in a gradation list of 48,
My lord,
if there is 24 and 24,
my lord.
that means direct recruitees will always be above.
Depends, my lord, when they inducted as a permanent cadre in the department, my lord.
No, I understand.
Suppose, my lord, the private respondent promoted in 2005. If the direct recruit is 2006, but they cannot supersede the, my lord, official promotion. They cannot. Had it been in same year, then, my lord, of course, my D1, P1, that can be rationalized, my lord. That can be done.
My lord, just one thing I'm showing.
No, but there must be, you see, are you saying that the vacancy, say, let us say that post number 1 is vacant.
My lord.
It is filled up by anyone in seniority, maybe direct, maybe promotee. It can be filled up, correct?
My lord. My lord,
so it is
as per now, so far I can understand the jurisprudence of service. Allows go to my lord P1, D1, my lord. P1, D1, promotion and direct recruitment. Yes, my lord. So if there is any one vacancy is there, then it will go to the promotion, not to direct recruitment.
Okay.
Yes.
My lord.
In this case, earlier your lordship had the occasion to pass one order, which your lordship will find it page 76.
Page
76.
76.
Of the writ petition, my lord.
76,
my lord.
76.
Ovidai, my lord, yes, my lord. Here, my your lordship has held, my lord, that department have exceeded the promotion quota. This is not disputed, my lord.
My lord, that judgment will indicate, my lord, that judgment will indicate that there is no vacancy to accommodate them prior to 2012.
No, matter is before the division bench, my lord.
No, division bench issue is different. My lord, what happened? My lord,
Same thing.
now I'm coming to 2012. The DPC recommendation may, my lord, lordship may kindly take, I'm indicating that, man. Kindly take my lecture, I indicated that, my lord. 2012. Basic for this. My lord, may just turn to page 3. I have indicated that writ appeal. That is slightly completely different issue, my lord. Lordship may turn to page 3, my lord. Date 24/7/2012. This is I am talking about.
This judgment is interfered with by an appeal court? No.
No, my lord. Appeal has been preferred. If no interim order. One interim order is there saying that he will not get any this interim order will not giving any benefit of getting further promotion, etc. Otherwise, this order has been interfered with. The appeal is pending. My lord, that is a slightly on a different issue, my lord, because lordship may kindly turn to page 21, paragraph I read, it will be clear.
Number?
Page 3 of this list of dates.
Yes.
This is the recommendation of 2012. Page 3. 21 JE. Lordship is what, madam? page number 3, 24/7/2012 date.
Page 3,
Page 3.
24/7/2012.
Yes, madam.
Yes.
21 JE who were promoted on officiating basis to the post of AE during the year 97, 98, 2002 and 2005. Among them, 18 JE were considered and recommended for regular promotion on 26/9/2007. However, the same was not given effect and thus, thereafter, finally the said 18 were recommended in the DPC dated 24/7/2012 for regular promotion. Among the 21, 3 incumbents could not be recommended as one incumbent died, one terminated, and against the other, there was vigilance case pending, and therefore, 18 numbers of JE were recommended for regular promotion with effect from the date of their officiating promotion. Among the said 18, also one Sri Pradeep Kumar recommended was kept on hold for a non-availability of SR and it was advised to play on the next DPC. Be that as it may, along with those 18 incumbents considered for promotion, 2 more incumbent JE, namely Imi Angu and Ama Palo, were also considered and promoted with effect from the date of their officiating promotion. These 2 persons' recommendation was put to challenge, my lord, in the writ petition, and that writ petition was allowed. And this recommendation of these 2 persons were set aside. So this has got nothing with has no bearing with our case, my lord. Their case is that, my lord, Lordship can see this 2012 recommendation I am showing, DPC recommendation I am showing for the purpose of saying that all the vacancies of 1997, 98, 2002 till 2005 were taken into consideration, and then all these posts were filled up. Now they are again claiming, these persons are claiming retrospective promotion from 2005. Now there is no vacancy. If you claim any such right, my lord, then you have to challenge this recommendation. This they have not challenged in the first writ petition. And secondly, we are not party, and not even we, many others whom they will affect now if they go to 2005. They have to make them, all of them, a party. They have not done it. They have not challenged this recommendation. Now 2019, my lord, when they were recommended, next page, Lordship, kindly see, my lord. Sorry. Hey. Now, next page, my lord. The 31/10/2019, 24 number JE, my lord, down below, my lord. 31/10/2019. 24 incumbent JE who were promoted on officiating basis, including the petitioner, the writ petitioners, during 2006 to 2017, were considered for promotion by a DPC dated 31/10/2019, but recommended promotion of 17 numbers of, including the writ petitioners, for promotion to the cadre of AE. This is what they have challenged, saying that no, this DPC recommendation should have recommended us with effect from 2005. Now, if you claim that, then you will have to challenge this 2012 DPC recommendation also, that you have not done, admittedly. Now I'll show my one document. My learned friend is showing the subcommittee report. Lordship may kindly see, my lord, page 16 of my IE.
Just a moment.
My lord. What they are saying is, my lord.
Just a moment. Okay.
Now, just 1 minute. Yes. No, just one thing I'm showing. Lordship may kindly turn to page 19 of my IA.
19 of your IA.
IA, madam. Now they are showing that vacancy existed like by showing that there's page 19, para 16.
Page number?
Page 19, madam. IA.
Paragraph
16.
19, paragraph 16.
My lord, the claim of the writ petitioners opposite parties as to that they ought to have been given the effect of promotion from the date of promotion on officiating basis, that is 2007 and not 2019, absolutely holds no tenable ground, as it being settled position for the right of consideration for regular promotion accrues on appropriate promotional quota becomes available. In 2017, the petitioner opposite parties promotion on officiating basis was in excess of promotional quota and not in adherence to ratio of 50-50 for direct recruitment and promotional quota, and thus the same shall not confer any rights upon the opposite parties. And just 2 pages behind that, page 17, we have said para 13 and 14. Let's kindly have a look at para 13 and 14. I would like to show what is their reply to that. In the reply, they have annexed one document showing that there were vacancies existed, and that document shows that some AEs were promoted on officiating basis to the post of EE. That is not a clear vacancy, my lord. There has to be clear vacancy. They have annexed this document, my lord.
You have a gradation list of those periods so that
Yes,
we can
ma'am.
identify.
Yes, ma'am. My lordship, just give me 1 minute, one document I'm showing. Page 62 of their reply to my IA, lordship, may kindly see. They have filed a reply. It will be running page 62, madam. Filed in September 20. And lordship, may kindly turn to page 62. Page 62, madam.
I'm there.
Para 10, they have replied to my contention in para 16. Now, lordship, may kindly see that with regard to the averment made in paragraph 16 of the IA, this answering deponent begs to deny the same and begs to state that and submit that the claim of IA applicant that the deponent's promotion on officiating basis was in excess of promotional quota is not based on any record, but it is a figment of their imagination. As a matter of fact, see, Yimi Angu had filed RTI application seeking information about the year-wise vacancies filled, and the reply to such RTI query shows that there has not been excess promotion of promotional quota. Now, these documents, they have annexed at page 156. Lordship, may kindly see page 156. (156) is the forwarding letter, my lord, and 156(7) is the document. Now, lordship, you kindly see these documents is year-wise vacancy position for the post of assistant engineer or assistant surveyor of work civil under DHPD AP. Now, lordship has seen name of the officer, date of joining. Then third is date of officiating promotion as EE. Now, if these persons were officially promoted to the post of EE on the dates shown, those cannot be considered to be a clear vacancy against whom they can be accommodated today by passing an order of retrospective promotion. And in the entire writ petition also, they have only claimed in the writ petition, earlier writ petition 2014, WPC 14, and in the presentation, they are claiming that right from day one, they have been continuously working and nothing else. Now, these they are saying on the basis of the directive of class 2 second principle. Now, I'll show how this is.
No, but then this calls for a full present hearing. We can't go.
My only
so
submission.
Technical appreciation and then say that the interim order.
My submission is like this. 2012 recommendation by the DPC has filled up the vacancies up to 2005. That is clear, my lord. That recommendation of DPC 2012 is not put to challenge. So, number one, my lord. Number two, my lord, if they claim promotion from 2005,
Where is that DPC
my lord,
that you showed us?
my lord,
DPC is this, what do you call 82?
page 82, Nikki.
No, not this 82 is not, there's something else.
The my lord, your lordship is asking about 2012 DPC.
Yes, where you say that 2005 was filled up.
2005 was filled up. This is, yes, this is 2012 the recommendation, my lord.
Where is that?
2012. Page 41 in the IA also, my lord.
41 of the IA.
41 in the IA. See, 41 together is 20. Oh, yes, please. Page 41 together is 20.
Because whatever you are submitting
Well,
goes to the root of the entire dispute.
otherwise it goes to the root, but what I'm saying is it can be very apparently seen.
Let us see. That's
Madam.
why we are examining it.
2012
41,
37, there is some mistake.
Huh?
37, ma'am.
37.
39 is type of.
39 is the type topic, ma'am.
Yes.
39, madam. Minutes of the DPC meeting held on so and so in the office chamber of Chief Secretary. The DPC meeting was held on 24/7/2012 under the chairmanship of the Chief Secretary of the Government of Andhra Pradesh. In his office chamber for regulation of the assistant engineer promoted on official basis during the year 97, 98, 2002, 2005 in pursuance of the judgment and order dated 30th of March 2011, Itanagar Permanent Bench, Nahalagunin WPC number so and so, constituted by government order number so and so. The DPC has thoroughly examined the service records of the officers and recommended following assistant engineers promoted on officiating basis for regularization with retrospective effect, with effect from the date of as shown against there, each name in pursuant to the judgment and order dated so
I
and
think
so.
other matters I'll not have time to take up. So other matters will be rolled over. Yes.
So, my lord,
If any interim order is required to be extended, please tell the postmaster. Only in those cases where interim order is to be extended, please tell the postmaster. Other matters will be rolled over. No, tomorrow it will not come because there is time. It will be rolled over. They will adjust it somewhere. Interim order extend करना your matter may not be taken up. We are discussing it tomorrow. Yes, Mr. Sharma.
Number 28, can it be on Monday next?
Just indicate it to him. I am not passing any orders, but.
Lordship has indicated Lordship is rolling it over for tomorrow. Lordship
No. Rollover means not tomorrow.
Not tomorrow.
This is already out.
Because
So
tomorrow I'll not be there.
tomorrow.
So Monday.
Just tell the court master. Yes.
so my lord, page 39, my lord,
Page 37.
39.
No.
39 is the type copy, my lord.
No, that's okay.
Right.
After this page 37,
Right.
where is the gradation list where we can find out their position? Because Mr.
Gradation
Nawam
list.
says,
Gradation list.
because Mr. Nawam says that one is the promoting and then direct recruitment. The adjustment is like that.
No, my lord.
It's subject to date of.
So, yes, subject to
the
date.
date of.
Subject to date. My lord, so far as we are concerned, 2009 we are directly recruited. There is no
correct.
dispute. 2019, they DPC recommended their name prospectively. Now, my submission is, my lord, in 2012, this DPC was held. This has taken into consideration the the need to regularize retrospectively from of the AEs from 2005. Their names were
That's why
not
you-
considered.
That's why I'm asking.
My lord.
You see the manner in which I am thinking may not be
no,
the
my
manner in which you are thinking,
No.
but you see what I'm trying to ask you is that if we have a gradation list after this 2007,
2007.
this recommendation is when? 2012.
12, yes.
2012.
My lord.
And in the gradation list which comes hereafter, you as a direct recruit of 2009 would also be finding place in that
Yes.
seniority list.
Yes.
So how are the persons fitted in this gradation list?
In this second,
The repetition as well.
No, you see, 2009 you enter,
my lord,
2012 is the DPC.
my lord.
Now, after this, there would be a gradation list.
Yes.
And how the persons are fitted there, I wanted to see that.
My lord, we are above them.
You are above them.
Yes, that is why they have changed in this present petition. They have only changed the gradation list. In of my lord, assistant engineer. AE.
Of which year?
My lord, of which year?
Up to nation list is
22.
22 gradation list is
Yes,
challenged.
yes.
So, Mr. Nawam,
Yes, sir.
now you get the point why I'm asking that.
My lord.
If that in the gradation list of after 2012 DPC,
My lord.
people are already given fitment in
Yes,
various
yes,
positions,
Yes.
and that not being under challenge. In a collateral proceeding, we can't held up the interim order, cannot held up Mr. Mazumdar.
But that is what I'm saying. In the first petition, if they get a stage matter different. In the first petition, there is no interim order, but in the second petition, which is where the challenge is to the consequential order, there is a
So
stage.
that's why you see, that's why I'm going back.
My lord, your lordship is absolutely correct. And in the first petition, my lord, if they have to challenge the 2012 recommendation, they have to make all those persons senior to them who were recommended a party in the
That
petition.
we'll examine, but
We are also not a
trying to-
party in the first petition.
Let us see how.
We are also not party in the first petition.
Let us see how, since I
My-
have a query, let us
My-
see how we are placed, then we'll come back to you.
My lord, so far, my lord, this 2012, my lord, DPC. But
My learned friend is appearing for the government. He should be with me because I am the.
no. I'm just,
No, he is
I'm just correcting the facts, man. I'm just
You see,
correcting the facts.
that is the beauty
He
of.
should be supporting the gradation list.
no,
but
no.
That's what I'm
No.
You
saying.
see, that is the beauty of Mr. Nawam, because whatever side he takes, but
Well-
he is always neutral.
Well,
Yes. That is absolutely, there is no doubt about it.
well, that's why I didn't touch the gradation list, either provision or final list. That's why I didn't touch my lord. My lord, so far this 13 and page 30, which my lord senior counsel are referring, the DPC of 2012. But this does not talk about the quota system. It's only talking about the regulation
No,
of my lord.
That's okay. But Mr. Nawam,
My lord.
after this exercise of DPC,
My lord.
some people got promoted.
Yes, my lord.
Then there has to be a gradation list.
Gradation list, absolutely.
How they are fitted
40.
in that
Well,
gradation list. There in 2009, Mr. Mazumdar gets a precedence,
My lord.
and they are fitted higher than others.
My lord.
Then his position cannot be disturbed. That is
Correct.
the prima facie view.
Correct, my lord.
Correct.
Correct, my lord.
So to find out whether the 2022 challenge to the 2022 gradation list upsets Mr. Mazumdar in 2012.
My
That
lord.
is what I want to find out. I'm going through a back door.
My lord, absolutely correct, my lord. Now, my lord, so far, my lord, gradation list is concerned, my lord. My lord, that was exercised in view of direct liberty was granted by the division bench, my lord. So that was carried out. The gradation list, my lord, the provisional one. So provisional one, it was notified to everybody, giving my lord 15 days time to
Okay,
place
where is
the
that?
objection.
Where is that?
My lord,
Page 41, man.
page 41.
41.
Now I'll be with Mr. Majumdar, my lord.
Yes. There was a provision list. Then there was a gradation, final gradation list.
That is not disputed.
Just to be kind of.
I'm absolutely with my learned friend.
That's why I
Page
told
41
you.
is the provisional.
Yes.
I've been hearing Mr. Nawam. That's why he gets a different what you
My
call a different respect when it comes to his submission.
Today I was discussing, my lord, I told him that we were discussing that he should get further.
My lord,
I was just
my lord, page 41, my lord.
Mr.
Page
Nawam,
41.
My lord.
there are certain things I can't hear. Hard of hearing. But whatever he says, he normally
My lord.
writes.
On page 41 it starts, 42 our names are there.
Yes, my lord.
21, because of the past
Tw-
instance.
22 to 25.
Just a moment. Twenty-six, 10, 21, and WA 11 of 2021.
Yes, my lord.
Okay.
If your lordship see my top, my lord, this is the provincial list as on 31st 3 2022, my lord.
Yes. My lord, between them and us, my lord, there are others also.
Yes, yes. Has your lordship got it, my lord?
Yes.
My lord, so per petition is concerned, my lord, serial number 44, 45, and 48, my lord. Serial number, my lord. Start from 44, my lord. Sri Tomin Ete, my lord.
44, Tominete.
Yes. 45 is a Vijay Pasang.
He is a petitioner.
Petition number 1. Then Vijay Pasang is the petition number 2, my lord. Then 48 Sri Shangmo Taing is the petition number 3, my lord.
And respondents applicants are from 22 onwards, man. Previous
Applicant are from
previous page, man.
Previous page, my lord.
Serial number 22, 23, and 25.
22 is
22 to 25, man. 22, 23, 24, 25.
25, correct.
okay.
And this
In seriatim, they are serial number, applicant number.
Applicant number, seriatim, applicant number. 1, 2, 3, 4. 1, 2, 3, 4, man. Serially.
Okay.
Then there is a final gradation list, my lord.
Now, if your lordship see, my lord, direct recruits, my lord, start from my lord, serial number 11, my lord.
Yes.
Yes, my lord.
Right.
So,
No, not 11, 12.
I'm sorry, my lord, 12. Your
Ah,
lordship is
12.
correct, my lord. Yes.
Yes.
All in same year, my lord. 2006, 2021, 8, 2006, my lord. It's up to, my lord, 25. Then there will be a little bit break, my lord. Yes, 22, there is a break, my lord. If you lordship see the year of assistant engineer, my lord, civil, that's a little bit different, my lord. It's 25, 8, 2009, my lord. So there must be second batch of the direct recruiters.
Second batch.
Second batch, not the first batch, my lord.
No, not the first batch.
So same serial list, you lordship will find in the final gradation list also. Ma'am. This is the provisional one.
Final.
Since they could not given any representation or against my lord objection within the time frame, so it was finalized.
No,
Your lordship-
they file objection, I think.
No. That is after the outer limit of time, my lord.
No, but it is mentioned in the final gradation list. It is mentioned.
No, I just check up the date. If your lordship see, my lord, they have filed a representation, no doubt about that. My lord. If your lordship see the
45.
dates,
It's okay,
my
I
lord.
accept your.
I may be wrong, my lord.
No, even if you are wrong, it doesn't matter.
Doesn't matter,
Because objection there or not, now we are hearing the repetition.
my lord.
That will come. That will come. Yes, Ms. Danjan.
So I may be wrong, that's what I'm saying. No? It's not in the representation.
After examining all the grievances, they filed representation also. Final gradation is prepared, our position is maintained. Manu, this is pursuant to our direct recruitment in 2009. And in the first representation, Manu, they have not changed. That's part of my submission, short submission. 2012 recommendation, whereby their seniors were promoted and they were given officiating retrospective of promotion from their officiating date, 2005, etc. That is not under challenge. Now, vacancies are exhausted. Now you say that only because you have officiated from 2005, you should be given retrospective promotion. That, if they fulfill the criteria of director to class 2, then it's all right. But director to class 2, before saying so, has relied on a judgment which says that vacancies were there, but then their appointment was officiating. But here the vacancies are not there. This is the difficult. So in any case, they cannot go beyond 2012. They can go, and we were born in 2009. So our further promotion, they should not. In the list of dates, I have given the entire background. In the list of dates, I have given the entire background dealing with each and every development. Just one information. In the first petition where they have prayed for retrospective effect, we are not made a party.
May I please, Lordship? Lordship, the facts have not been made very clear. So therefore the confusion. What happened is, after the DPC 31/10/2019, in which our promotion as assistant engineer was regularized with effect from the date of the DPC, that is 31/10/2019. Thereafter, we made several representations saying that the posts were vacant since 2005, 2007, much before they were appointed in 2009. Even before that, suppose we say 2005, there are no posts. Even thereafter, records will show that there were posts in 2007, in 2008. Yeah. After the DPC was conducted, we made our grievances known. Government, in trying to resolve our issues, constituted a subcommittee. The subcommittee, my learned senior has read out, has made observations about. Lordship may see the subcommittee report once again. In my reply to the IA, page 146. Lordship may see page 147, the second paragraph from bottom. (147). This is the minutes of meeting of the subcommittee report. Coming to the vacancy position against promotion and direct recruitment, during 2005 is 33 posts. The division of posts between the promotion and direct recruitment is 33 posts shall be 33 divided by 2 equal to 16.5. That is 17 posts shall be filled on promotion and 16 be filled on direct recruitment. All these committees were made on all these appointments were made on officiating basis, deviating from the provision of the recruitment rules besides the procedure of departmental committee meeting. Accordingly, in the year 2005, requisition for 10 posts of assistant engineer were submitted to the Arunachal Pradesh Public Service Commission for conducting recruitment process in the year 2005. Again, in the year 2007, another 4 posts were sent to the APPSC for conducting recruitment process by letter dated this 29 August 2007. However, there were 17 posts which fall against promotion and 16 posts which fall against direct recruitment. Also, 3 posts against promotion and 2 posts against direct recruitment were in hand as per the record. The process for direct recruitment took a considerable time, and the commission recommended appointment of 4 posts in the year 2009 and against direct recruitment vacancy. In the meantime, the department had appointed few junior engineers as assistant engineer in the year 2005 against the above mentioned vacancies. So these officers are claiming regular promotion against the above mentioned 4 promotion vacancies. The recruitment rules to the post of assistant engineer 2005 provides that by promotion from amongst junior engineer to the department who have held 8 years of regular service or for diploma holders and 5 years regular service in the degree holders, provided that irrespective of seniority in the cadre of junior engineer, promotion to the post of assistant engineer shall be considered in order of seniority on completion of respective qualifying service. Then Lordship, the names are mentioned in the last paragraph in 148. In view of
you see.
Yes.
When you are reading this part.
Yes.
There is another judgment, I think Mr. Mazumdar will find out for me.
Yes.
In connection with service parlance.
Yes.
Supreme Court has clearly laid down.
Yes.
That a challenge when the rights have already been 45.
Yes.
After long years.
Yes.
Should not be entertained.
Yes.
Now, if we are disturbing, if we are disturbing a seniority position of 2005.
Lordship.
Now we are in 2024.
Lordship.
20 years almost. Can it be done?
Lordship, that time, our seniors were from.
You see, I'm referring to a Supreme Court judgment. I don't have that readily, but I think he will find out for me.
Yes. But Lordship may once hear what I'm trying to say. Now, Lordship, after this subcommittee report, there was a provisional seniority list published in the year 2020 after the subcommittee, because subcommittee report recommended that report recommended that in the last page of
Is there any reason in your
yes,
stated in your
that
petition?
committees of the opinion that appointing authorities should dispose of the representation submitted by the promotees and direct recruitments, if any, and finalize the relative seniority of the direct. That is.
You're reading which page?
This is the recommendation of the subcommittee 151 of my reply to the IA.
151.
Yes, the last page. The first paragraph, my learned senior government advocate has read out. So the total post starts. So the total post. So the total post of assistant engineer is 48, and each line promotion will get 24 posts, and the direct recruits will get 24 posts each as per their avenue. As per the above statement, the department had filled up 24 posts of assistant engineer. Being the officiating vacancies, the committee had been informed that the department had never conducted departmental promotion committee meeting and going on filling. Sorry?
Just a moment.
Yes.
If this paragraph we are reading, I have understood correctly.
Yes.
It's general principles of seniority. The
Yes.
relative seniority of direct recruits and promotees
Yes.
shall be determined according to rotation of vacancies between direct recruits and promotees.
Yes.
Which shall be based on the quotas of vacancies reserved for direct recruitment and promotion respectively in the recruitment rules. Correct?
Yes.
Mr. Navam is saying that the position would be number 1 for promotees, number 2 it will be for direct recruits.
Yes.
Now, if Mr. Mazumdar is showing us a gradation list where from serial number 12, all the direct recruits are placed together.
Bunched together.
Correct.
Yes.
And that is because of the date of appointment. Correct. Now, if I read this paragraph 6, general principles, would it mean that the date of joining would be irrelevant and the distribution would be number 1, irrespective of the date, it would be promotees and direct recruitment, irrespective of the date of joining or seniority. Is it right?
as per the principles of seniority and as per the, there was some memorandum which was a subject matter of N.R. Palmer's case and Megha Chandra case. What was given there was a memorandum of 1986 in which how these things have to be done were mentioned. According to that, if suppose there are 10 posts, but suppose there are only 3 direct recruits and the rest are promotees. In such a case, suppose in the year 1986, some 10 posts were to be filled up, but there is a shortage of one part of the quota, that is suppose in this case the direct recruits. In that case, will stop at the, suppose it would be P1, D1, P2, D2, like that. So now there are more promotees than direct recruitees. Then the promotees will be bunched up together in the last. Then this will be adjusted in the next year as per the quota of the vacancies. This is how it should be done. Now, Lordship, we are not all dead at the moment. At the moment, what I'm trying to say is, as per the subcommittee report, the subcommittee report had itself said department had not conducted departmental promotion committee meeting going on filling the post of chief engineer, executive engineer on officiating basis. Therefore, these claims and counterclaims had occurred. Now, what the subcommittee report has said that there were 48 posts at that point of time and 24 posts were for direct recruits and 24 for promotees. But since these have all the promotees quota have been filled by only officiating appointments. So therefore this problem arose. So that is why as per the subcommittee report, when the department had issued a provisional seniority list in the year 2020, it was kept in abeyance, saying that until we act upon the subcommittee report, will not go for further seniority, will not finalize the seniority. That is the reason why, Your Lordship, we had not sought interim order in the first writ petition. Because at that point of time, even the seniority list of 2020 was kept in abeyance. This I will show, Lordship, from my annexures.
No, that's, yeah, but I'm still.
That's the reason why. Then during the pendency of, Lordship,
I'm stuck up with the same thing which I've asked Mr. Nawam and which I've repeated about the placement of the people in vacancies.
Yes.
In the gradation list, you referred to the case of N.R. Parmar.
Yes. Though that was overruled by Megha Chandras.
I understand, but in N.R. Parmar.
There was a memorandum, 1986.
But in N.R. Parmar, if I remember it correctly.
Yes.
It was held that the rota quota policy would be applicable, but the vacancies should be of the
recruitment year.
What you call, it is applicable in the year of vacancy.
Yes, the year of vacancy in that case was held to be meant the year of the initiation of recruitment, which was overruled by Megha Chandra's case, saying that in N.R. Parmar's case, the OM of 1986 was misread because of misunderstanding of because the 1986 basing on the reading of 1986 OM, N.R. Parmar had said that. But in Megha Chandra's case, it was overruled, and Megha Chandra's case said that 1986 memorandum never intended to say that. You have in N.R. Parmar's case, it was misread. So therefore, it was overruled. In that, the basic difference between these two cases is that in N.R. Parmar's case, what was held that the year of recruitment would be the year of initiation of the recruitment. But in Megha Chandra's case, what was held that it cannot be. It cannot be because somebody who is not born into service cannot have a place in the seniority. For example, in 2007, they have issued that, how is recruitment initiated. In the case of, maybe in the case of promotion, it will be sitting of the DPC, calling for papers and sitting for DPC. In the case of direct recruitment, advertisement, sending the, what is that word called? Sending the requisition of the post to the Public Service Commission. Then thereafter advertisement and this and that. So the year of initiation of recruitment as per year of initial recruitment, maybe 2007, for example. But it will ultimately be finalized maybe after 1 year, 2 years, maybe 2009. So in 2009, if somebody gets into service, what NR Parmar said is, because of the delay in the recruitment process, that cannot be attributed to the persons who are appointed. So therefore, the year of recruitment should mean the year of initiation of the recruitment. That in that case would be 2007. This is what Megachandra case had overall, saying that before 2009, the year of appointment, you cannot have you are not even born in service. So that cannot be, and you have misread the 1986 OM. That's what was held. So, Lordship, coming back to this, the reason why we did not ask for interim order at that point of time was because in 2020, when they had published a seniority list, which we have objected, they have realized their mistake and they have said that they have issued an addendum saying that we'll keep this in advance until we act upon the subcommittee report, which was not acted upon. Then time went by, we filed the case. We were expecting good results, but in the year in 2022, they finalized the seniority list without acting on the subcommittee report. Now, as for we have during the filing of the first writ petition also, and in this reply also, we have annexed certain documents which your Lordship will see. These are documents when the subcommittee report said, before that also, there were some office notings discussing these points. Now, Lordship will see at page 121 of my reply. Yeah. Of my reply. There are several of this, but this 121 of my reply. This is the file noting of the department. Here the vacancy positions are mentioned in page 123. In 2005, there were 13 new vacancies, 11 new.
What is this page 121?
(121) is a file noting of the department. Because after before the subcommittee report said, there were because there were representations from both sides. So that is why this was discussed. And there are several of these things.
Yes.
Then at page 123, part of the same thing is the vacancy position as per their records.
No, this is only a file noting.
Yes, file noting. Then Lordship, 124, page 124.
File noting is not a record.
Lordship.
File noting is an opinion of the person who is writing the file.
Yes.
And therefore, there are judgments.
The problem here is, Lordship, the problem here is whether or not these vacancy positions as mentioned here, whether or not this is true or not, it is for the government to find out. Government has not filed affidavit. Now, Lordship, before that, Lordship.
Then, Ms. Janajan.
Yes.
Then you are in a disadvantageous position.
Yes.
Insofar as the submission of Mr. Mazumdar is concerned.
Yes.
Because if it is a 2012.
Yes.
Which is not assailed.
We had no reason to assail that, Lordship, because at that point of time.
Then you can't disturb the position of Mr.
At that point of time, Lordship, even if now I will be sort of changing my stand in the sense that even though we're appointed in 2005, we were not given financial benefits until 2009. But even that date, when we were given financial benefits, even that date is prior to their appointment. So even if we don't, even if they say that in 2000, because what they are saying is in 2005, there were no posts. That time, the post was only 31. Thereafter, so many posts were created in 2007, 2008. There also, suppose I admit to what my learned senior has said, that there are no posts. Suppose I admit to that. Then also,
No, even otherwise, you see the second submission is
Yes.
also carries a great force.
yes,
That in the writ petition, their seniority position was never assailed. They are not parties in the writ petition. They have only merely come here not to impede themselves, but to vacate the order.
yes.
So if they are not parties, their position.
No, they are
is
not
kept.
parties in the first writ petition. In the second writ petition, they are parties. In the first writ petition,
No, but
our
this-
prayer was only to,
No, parties, seniority
our
position.
prayer was only to review the DPC. Because in terms of the, an act in terms of the subcommittee report. We simply said, kindly do as per your subcommittee report and kindly give us our due retrospective promotion. That was what we said in that first writ petition. That time there was no problem because the government was also said that we will not go ahead until we act upon the subcommittee report. That was not done. Now, Lordship, may see page 124, just for a moment, Lordship. 124, same file noting. As per the observation of the AR, the second paragraph, 11.11, as per the observation of the AR and the vetting of the law department, it is prudent that existing promotional quota posts in the year 2005 was 7, in 2007 were 2, in 2008 4, and in 2009 3. That is 7 plus 2 plus 4 plus 3, 16. As such, these officers who were appointed against 16 vacancies on functional officiating functional basis in the Department of HPD in different occasions. Therefore, the justification of the A's for fixation of their seniority from the retrospective effect seems to be genuine as per the clearance of the AR and the law department. Then the finding is as per this person, page 125. Further, it is also mentioned that in the said rule, there are instances that are exhaustive, not exhaustive, but only illustrative. Further, a review IPC is considered
No, you
only
see,
the,
I'm unable to follow this. The reason is
yes,
because I am pitted with Mr. Mazumdar.
yes,
He is a direct recruit.
yes.
If you alter the position, it will only be altering the position of those who were promotees. His position can't be altered even if your petition is allowed. You can't take away and step into the shoes of Mr. Mazumdar.
No,
But he
Lordship,
was-
if I'm given a retrospective promotion, if my promotion is said to be prior to him, then my position in the seniority would be higher. That is, it is not that I'm against only the promotees, Lordship.
No, but you see, it may be higher than you. But,
Yes.
But how you are disturbing his position?
My lord, may I just indicate one small information? Page 78 is an order passed by your lordship, incidentally. There, my lord, in 2012 DPC, 2 persons were in excess of the quota. And they also prayed for retrospective promotion from the date of officiation. Your lordship has held that it is in excess of the quota. So if these 2 persons cannot be granted, how these petitions can be again given?
No,
retrospective promotion?
even if she succeeds,
My lord,
she will succeed only to dislodge those persons in the promotional quota.
yes,
They can't dislodge you.
no.
Assuming that X or Y is senior to you, doesn't matter to you. If he's from a promotional quota
So she.
and instead of A, B becomes senior to you, doesn't matter to you.
Well, possibly she is saying that if she is given promotion with a retrospective from 2005, then I have come in 2009, then she can dislodge me. This is what she is saying.
Yes, Lordship.
Okay, but now also somebody is there for 2005.
That's what I'm saying, ma'am. From 2005, this judgment, if your lordship, this aspect, this 2012 DPC recommendation has been discussed by your lordship in
So
this
you may become a senior to Mr. Mazumdar,
Yes,
correct?
yes.
Let us say that there is a possibility that you can still be ahead of him. But you are,
I'm not a
you will
party
be
in the-
dislodging, you will be dislodging whom? You will be dislodging somebody who is in the promotional quota. You can't dislodge a direct recruitee.
And my lord, technically, my lord, in the first.
You see,
petition-
somebody A, let us say A is a direct, is a promotee. Correct?
Yes.
He's a promotee. His promotee may be of any year. Let us say he came in 2012.
Yes,
We are just giving horrible examples.
Yes.
A man is of 2012. He is now above Mr. Mazumdar, who is a direct recruitee of 2009. Correct?
No, sir.
I'm giving a very horrible example. 2012 is ahead of Mr. Mazumdar. He's a promotee. You dislodge that man, and of 2005 you get it. How does it alter Mr. Mazumdar? That is the only question I'm asking. In 2009, it is not that you see, you see, when somebody is placed in a gradation list, it's not that you are pushing him down. If rota quota is stated by Mr. Nawam is accepted, then there is no way that you are dislodging Mr. Mazumdar, whether he is of 2009 and you are of 2005. You will dislodge only that person who, instead of 2005, was below you and you overtake him. And this man comes to a lower position. And it cannot be that 20 plus 20, 40, 24, 24, 48 places are there. So if there are more promotees, you push out the direct recruits out of service. Let us say not only you, 24 more people succeed in the writ petition. Will he be out of service?
And this one.
No, Lordship, but if I'm given promotion from an earlier date than 2019, if it is 2005 or 6 or 7, if I'm higher than them, then obviously I'll be placed higher than them. But regarding other promotees, Lordship, all are similarly situated. It is not that anybody is higher than us.
That means you want that the promoting quota should exceed the direct recruitment.
No, Lordship, that will depend on the quota, of course. It is not.
Please tell me, I'm asking you a question.
Yes.
If there is a gradation list in front of you.
Yes.
You tell us whom you are dislodging, whose position you are altering. If you succeed in your writ petition.
The private respondents here who were appointed in 2009, 20.
That means you will be dislodging direct recruits.
It is not that, Lordship, that I will be taking up the quota. I will be, because it is not that.
If you ask me a provision of the statutory law.
Yes.
Correct. Procedural law, wherever it comes. Maybe I can tell you some answer. But if this is a case of pure and simple service law, you must assume that I do not know it. And therefore, please answer. The 48 people are ACs, out of which 24 is direct recruit, 24 is promotees. Now, if you succeed, do you push him down, or rota quota is available and therefore the fitment would be in that manner? Or number two, supposing 24 more people like you succeed, then whether Mr. Mazumdar will be out of service?
Of course not, Lordship.
Then whom you are dislodging? That is the natural question I'm asking you.
I am seeking to dislodge the the private respondents who have been appointed in 2009, 25/8/2009.
First petition, they have prayed for retrospective promotion from 2005, but the persons whom they are going to affect, they have not made them party. At least we are not there. We will be affected. Secondly, when 2012 DPC recommendation, they have not challenged. And most important, they are again and again saying their whole case is that we have continued since 2005, and there is no interruption. But then you are saying so, but then unless you show that the vacancy existed in the entire petition in the first and the second, my lord, they have not shown anywhere that vacancy existed. Rather, my lord, in the judgment of page
No,
78.
it may be so. You see, we don't know this
My lord.
situation because you have not gone into the repetition.
My lord.
Basically, we are trying to analyze your interim application and then we are asking
My lord,
questions here and there. So number one, there may be a case that in 48, what you call cadre of ACs,
AC.
24 are vacant
My lord.
and 24 is filled up by ad hoc promotion.
My lord.
Now, maybe that these 24 vacancies were belonging to direct recruit quota. We don't know at this stage.
Yes.
Those data is not before us.
In fact, their initial appointment itself shows that it was against our directory quota, my lord.
Where is that?
Yes. My lord, page
25 of the
page 25 of the petition.
27 of the rate petition.
25.
25.
My lord. Yes, sir. 25. Petition. 295. 295.
Hmm.
25 of the rate petition. This is pair.
My lord, may kindly see 25.
25 is the rate petition.
Oh, yes.
14 of 2022.
But repetition
295,
2024.
Rate petition
295 2024.
295. Yes, I got it.
Page 25. There are 3 minutes.
25.
Madam.
Yes.
There are 2 lots may kindly see first. This arrangement is purely on temporary basis and will not be based.
I may not be able to dictate the order. You just say, heard Mr. R. Mazumdar, counsel for the applicant, senior counsel assisted by Mr. B. Quashing, counsel for the applicant. Also heard Mr. R. S. Nagam, then an additional advocate general for the state, and Ms. N. Benjamin, learned counsel for the private respondents, or private respondents who are the
Opposite parties 1 to 3.
1 to 3.
Second order.
Okay, you are 1 to 3. Okay, respondent number 1 to 3 in this application, who are the petitioners in the connected WPC 295 EP of 2024. Full stop. Arguments are concluded, judgment reserved. Order reserved. It will not be judgment. Yes.
Madam, just
Because I'll have to excuse him, otherwise there may many dictations which can't be typed.
Madam, I'm just showing 2 pages, nothing else. Page 23, lots may kindly see. Page 23.
23. 3.
Miss. This is the first order of 2005, whereby they were given petition number 1 was given the allowed to hold the charge of AEs.
23, yes.
23. Now, Lordship may straight we go to page 25. From 2007, it was changed. Page 25. ma'am.
25.
Yes. Now, in partial modification of that first page 23 order, now Lordship may straight we read para 2. This arrangement is purely on temporary basis and will not bestow on them any claim for regular promotion as assistant engineer civil in the Department of Hydropower, etc. And that the functional service so rendered would not count for the purpose of seniority in the grade of assistant engineer and eligibility for regular promotion, conferment, etc. Now, this is important. The functional promotion stroke appointment is against the quota reserved for direct recruitment of assistant engineer. And as soon as the government appoints direct recruitees to the post of assistant engineer, the functional promotion appointment made on so stand terminated.
Good.
Stand terminated and they reverted back to the post of junior engineer civil. So, my lord, now subsequently, when these direct recruit quota was advertised, 4 persons were appointed, including us, and they were had to be disclosed. From that day, government passed on the same day in order to ensure that there is no break. Another order was issued to ensure that they officiate again. But we got our the direct recruit post against which they were working were given to us after we.
And then they were allowed to be officiating promotion in for different vacancies.
Yes.
Okay. All these 4 people are the petitioners. 1,
my-
2, 3, 4.
Yes.
They are the petitioners.
Yes.
Okay. End of the matter.
Lordship may see page 27.
27.
of that same.
Yes.
27. This is in
Pay scale.
respect of.
Then they were given pay scale. But then
They were given pay scale in
No,
in
no.
4th February 2009. This is still prior to their appointment. Their appointment is 24/8/2009.
That doesn't disclose them.
Lordship.
Your officiating appointment in 2000.
Now your lordship has only to see whether or not between 2005 to 2009,
wherever you
they
go,
were,
Ms. Daniel,
yes,
the other way of looking at it.
yes,
Wherever you go.
yes.
But once Mr. Mazumdar demonstrates that it is the direct recruitment vacancy, at least you can dislodge many others, but not Mr. Mazumdar.
This lordship, this document just by itself cannot say to mean that it,
Petition.
lordship.
It is not Mr. Mazumdar's rate petition, it is your rate
Yes,
petition.
yes, lordship. It may be so that at that point of time,
You can produce a document and then say disown it when it backfires.
lordship, my point is, suppose we say in 2005 there were no posts, so we were given promotion on direct recruitment quota. Then also in 2007, in 2008, in 2009, the posts were created. They were promotional posts. Now in 2009, that is why in 2009, in 4th February 2009, we were given financial benefits. Now, lordship, because there was a post of promotion quota, that is why we were given this. Now, lordship, their appointment is on 24th August 2009. That is later in time than 4th February 2009. Only because the department did not conduct a DPC at that point of time, the posts were filled up on officiating. Not only us, all the other promotees were on officiating basis. The question will be whether or not they were posts between 2005 to 2009. That the government has to answer.
But in any case,
Yes.
can you dislodge a direct recruitee?
Lordship?
Can you dislodge Mr. Mazumdar?
If I'm appointed earlier to him, obviously, lordship, because my benefits were given on 4th February 2009.
If it's a rota quota,
Yes.
the what you call the position of the direct recruits vis-a-vis the promotees.
Yes.
Will always be fixed. That will not interchange.
Yes, but that will be subject to the vacancies, lordship, year-wise vacancies.
Year-wise vacancies.
Yes. The vacancies, the quota will have to be adjusted as part of vacancies.
Correct.
Yes.
So
Then only because the government did not,
No, you see that's why in your pleadings you must make a specific averment. Whom do you dislodge? That's what from point one I'm asking that whom you are dislodging. You see, you can't in a fight between the promoters and a direct recruitment. You can only touch those persons who are promotees. You being of the same what you call the same position. 2009 recruitment, if it comes, it was a how many people were recruited then? How many people were recruited? In 2009, how many direct recruitment were there?
Four.
Only four.
Yes, only the applicants. Only the applicants.
So their position will never change.
And through Public Service Commission.
Their position will never change.
Minor Lordship have it.
Because in 2009, they will have to
Government has taken a decision, they're not going to review the earlier ones. So they want basically review. This is what they are saying the rate petition.
I have no instructions on this. Oh. This I'm seeing for the first time. This I'm seeing for the first time. I have no idea about this. Otherwise, this could have been challenged.
And what is the judgment?
Yes. SB Patwardhan. Relying on this, my lord, the Supreme Court has said that from the date of officiating. But this judgment has very clearly
No,
noted.
not Patwardhan. This is
Madam.
not this. The dislodging of seniority position.
Oh, my lord, yes, that.
Hmm.
But I'll give it tomorrow morning, I'll punch.
Huh?
Tomorrow morning, I'll punch.
My lord, we'll continue tomorrow, my lord. It's already 5:35.
It's over. my lord.
Yes, yes.
I mean, Lord, Sir, kindly allow me to go.
No, it's over.
It's over.
It's over. All good things must come to an end.
My lord.
My lord, sorry for interruption. My lord, item number 33 and 34. I'm really extremely sorry, my lord. I forgot to mention that the interim in the board the matter, interim, it was
30?
supposed to be continued. It was mentioned.
34, 35.
Yes, no, 33, 34.
34. Well, you made a mention in the morning.
I'm extremely.
I think those orders are all signed and even online.
Or this morning, today.
All those orders are signed, except for this order and the last 2-3 orders remaining. All orders are signed.
You have to pay IA for restoration of interim order.
For continuation, please ask him. Orders are online? Huh? All online? Just check it. If it is online, we'll get it here. Just a moment. No, because when I say that I am going for a rest, it is in fact
Works there.
it is not pending. No, not a single file is pending, except for one order where it went for retyping.
Huh? If it is signed, you have to sign it.
तो कुछ क्या है ना mention में 34, 35. 34, 35.
Yes, 34, 33, 34.
33, 34.
Yes, last two items.
हाँ
Last
last
item.
34, 35. आज का ऑनलाइन हो गया क्या मुन्ना से दिया था मॉर्निंग मेंशन कौन दिया था हाँ हाँ हो गया अपलोडेड
My lord, I'll find person.
No, it's okay, please do it. We'll extend that interim order. Mistakes do happen. I don't take an exception to that, but because in the afternoon, in the day, whenever I have time, I sign it.
My lord, can you file an application?
Yes. I don't take it, what you call, I don't take an adverse opinion of that because mistakes do happen. I don't.
My lord, I'll
Please do it. We'll extend it.
tomorrow it's.
No, it's okay. Why you should be sorry? Mistakes do happen, I said.
Deeply obliged, my lord.
I
detained the court till 5:30.
No, it is still early. I have set in the clock till 8:30.
For your lords, yeah, I'm told. Deeply obliged.
I'm carrying a headache with me.
My lord.
I'm carrying a headache with me. Actually.